Good morning to those of you in the Caribbean and the Americas. Good afternoon to those of you joining us from Africa, Europe, and Asia. My name is Matthew Rance, and I am one of the co-chairs of Young ICCA. Together with my co-chair colleagues, Maria Atanasio and Manis Jain, as well as Anna Quimbertrigo and Roldande, Young ICCA's events coordinators, it's my absolute pleasure to welcome you to this workshop on the use and appointment of arbitral secretaries. For the purposes of this webinar, we're going to be relying and discussing on the Young ICCA Guide on Arbitral Secretaries, which is a publicly available document that was generated by Young ICCA Task Force back in 2015. The views and comments and opinions within that guide are those of the guide itself. They don't necessarily represent the views of ICCA. And we've asked the presenters in this workshop to rely on that document itself. So the views in the guide do not necessarily represent those of the panelists on today's workshop, nor of their employers. Hope you enjoyed that lawyer speak. If you've never heard of arbitral secretaries, don't worry. We've designed this session to provide you with the foundational knowledge that's necessary for you to be able to sort of hit the ground running. And what that means is that we're going to start things from a kind of low level and build up. So with that being said, and I think just like the rest of the other workshops that Young ICCA has put on, it's important for me to mention that we'll also be offering you the opportunity to participate in a practical exercise at the end of this webinar that you can choose to complete if you'd like, with a group of up to 4 other webinar participants. We'll be awarding certificates of participation to all those that complete the exercise satisfactorily by October 13th. And in case a certificate is not enough to get you motivated, we're also going to be awarding some very exciting prizes that you'll hear about in due course. So if you're watching this live and you're interested in participating in that practical exercise and being eligible for the prizes, please stay tuned to the end of the webinar, and we'll be explaining the procedure on how to participate at the conclusion of this workshop. Now, before we begin, just a few words about Young ICCA, which operates under the auspices of the International Council for Commercial Arbitration. It has a mission to open the doors of international arbitration for young practitioners and students. Young ICCA is now over a decade old, and it includes close to 10,000 members, just like you, from all around the world, who are provided with free of charge resources and programming in 4 key areas. Those 4 key areas are the mentorship program, the blog, the workshop program, as well as full tuition scholarships. So the mentorship program connects small groups of Young ICCA members with leading practitioners for 2-year cycles. Applications for the mentorship program are open towards the middle of the summer each year. So they've actually just closed for 2021, excuse me. And all the application materials are made available on Young ICCA's website. In terms of the full tuition scholarships, we have 3. They are for graduate programs focused on international dispute resolution in the United States, in Switzerland, and in China. Each scholarship has its own opening and closing date, and all the information about how to apply is also on our website. Now, third, we run a blog which receives, edits, and publishes short articles on leading issues in international commercial arbitration. Selected articles on the blog are echoed by Clue Arbitration for maximum impact. And fourth, we run workshops just like this one throughout the year. And for those that aren't familiar with our parent organization, the International Council for Commercial Arbitration, or ICCA, it's a storied NGO which was formed 60 years ago to promote the greater knowledge and understanding of international arbitration worldwide. From its bureau in the Peace Palace in The Hague, the ICCA does this by taking on a number of important activities. Among them, it produces authoritative publications like the annual yearbook of commercial arbitration and collections of country reports in the ICCA handbook. It organizes a biennial congress, which is the largest regular event dedicated to international arbitration in the world. It facilitates trainings for judges on the application of the New York Convention. And finally, it operates a wide variety of projects tackling current issues in the field. So once you're ready to take the next steps in your career, we at Young ICCA would encourage you to get involved and become a member of the ICCA community and help contribute to this field that we all love so much. With that being said, it's time for the main event. And I'm very honored to have a stellar field to present to you today, including a very distinguished introductory speaker, Mr. Garth Schofield. Garth is a senior legal counsel at the Permanent Court of Arbitration. At the PCA, Garth has administered numerous arbitrations and works closely with arbitral tribunals constituted in some of the PCA's largest and most complicated proceedings, including maritime boundary disputes, territorial disputes, disputes concerning the application of international environmental law, investment disputes, and commercial disputes between private parties and sovereigns. In the majority of these cases, Garth acts as registrar or secretary to the tribunal. In addition to this work with tribunals, Garth assists the PCA Secretary General in the designation of appointing authorities and the appointment of arbitrators under the Untitled arbitration rules. Garth was one of the drafters of the Young ICCA Guide on Arbitral Secretaries, and Garth, we're really honored to have you with us. Thank you so much for accepting our invitation. The floor is yours.
Thank you, Matt, and thank you to Young ICCA for the invitation to speak today. So as Matt mentioned, throughout today's discussion, you're going to be hearing frequent references to the provisions of the Young ICCA Guide on Arbitral Secretaries. Hopefully some of you have read this before coming to this session, but if not, I'm going to be saying a few words about what the guide is and how it came to be. I should note at the outset that my participation in the task force that produced the guide was in my personal capacity, not necessarily representing the views of the PCA, and that also holds true for my remarks today. So the Young ICCA Guide was developed following a panel on arbitral secretaries that took place during the 2012 ICCA Congress. And I note that Nyusha, who's on the line here today, was one of the members of that panel, as well as a member of the task force. So I expect that later on, she'll tell you that everything I'm saying is wrong and give you the correct version. But back in 2012, the premise of that panel was a perception that many of the most prominent arbitrators were making effective and responsible uses of arbitral secretaries in their work, but that at the same time, much of the literature and discussion of arbitral secretaries that was out there was very reluctant to acknowledge that arbitral secretaries would ever do anything beyond the purely administrative work. And that as a result of this, that many arbitrators were in fact feeling constrained to be less than fully transparent about how they were actually using arbitral secretaries. So that the panel and also the task force in producing the subsequent guide went out and conducted a pair of extensive surveys of counsel, arbitrators, and institutions on how arbitral secretaries should be used or shouldn't be used. And the results of those surveys are reproduced in the back of the guide. The guide was then an effort to capture that research and to try to set out a majority view on the best practice in the use of arbitral secretaries. Now, that doesn't mean the guide is the only answer to these questions. There's a great deal of variation in national legal cultures with respect to the use of judicial clerks in national courts, and likewise in respect of the work of arbitrators. And expectations may also vary between ad hoc and institutional arbitration, or between different types of arbitration, including commercial arbitration, investment arbitration, or interstate proceedings. Moreover, the guide is what it's intended to be, what its title suggests, a guide. It provides a common frame of reference, and that may help usefully to align expectations and avoid surprises. But unless it's specifically adopted as such, the guide is not binding. And moreover, it expressly notes that it is subordinate to any binding rules that may on the use of secretaries that may exist, whether in national law or of the seat or in the policies of an institution that may be administering the proceedings. The guide seeks to address 4 issues. Should arbitral secretaries be used? How should they be appointed? What role should a secretary perform? And how should the secretary be paid? I'll say a few words on each of these very briefly, but largely these issues are what are going to be developed in the subsequent panels. On the use of secretaries generally, the guide is in favor of their use where it contributes to the effective and efficient resolution of the dispute. But it takes the view that arbitral secretaries should only be appointed with the knowledge of the parties and, at least in non-institutional contexts, with party consent. And it leaves the responsibility on the arbitrators to supervise the secretary and ensure that the decision-making mandate is not delegated. On the appointment of secretaries, the guide takes the view that the secretary should be appointed only after the parties have received details of the individual being proposed and a chance to raise objections. And I'd note that there different practices will apply in the case of institutional tribunal secretaries, what you'll see in the PCA or at ICCA. On the role of the secretary, the guide endorses the view that the secretary's role may and often will go beyond the purely administrative. And it sets out a list of possible tasks up to and including the drafting of appropriate parts of the award. But it leaves it to tribunal discretion what tasks should be entrusted to a secretary in any particular case. And on costs, the guide adopts a twofold approach. If the tribunal is being paid on an ad valorem basis, i.e. a lump sum amount based on the amount in dispute, then it takes the view that compensation for the secretary ought to come out of the tribunal's fees. On the other hand, if the tribunal is being paid on an hourly rate, compensation of the secretary ought to come from the parties, since the work done by the secretary will reduce the tribunal's hours. But in both cases, the cost of the secretary is not increasing the costs borne by the parties. Now, that was a very, very brief overview of the key points raised in the guide, and my colleagues on the subsequent panels will develop each of those as we come to them. And I'd simply note with one closing introductory point, the guide was published in 2014. Obviously, this is not a static issue. Since then, in particular, national courts in the Netherlands, Belgium, and the United Kingdom have considered the use of arbitral secretaries as that issue has arisen in the course of set-aside proceedings following the issuance of an arbitral award. And so far, courts have generally endorsed the robust use of arbitral secretaries, the same position taken in the guide, and confirmed that the line between permissible and impermissible use of a secretary really depends on whether the tribunal has delegated any decision-making rather than whether the secretary was entrusted with particular tasks, up to and including drafting. With that very brief introduction, I'll now hand over to colleagues and look forward to discussing this further.
Thank you, Gar, for your very brief but very broad and interesting first look into the Young ICCA Guide on Arbitral Secretaries. I'm sure we'll be able, going forward, to pick on bits and pieces of what you said and expand and carry forward some of the points that we wish to address here during this event. Thank you so much for this brief overview. And we will now, it is incumbent upon me now to transition to the next part of this event, where we'll be discussing the role of arbitral secretaries. So we will devote the next 25 minutes to taking as a starting point Article 3 of the Young ICCA Guide on Arbitral Secretaries. So on this specific point, we will have two very interesting contributions by two distinguished colleagues who will share some of their views and their experiences with us. So first, Lindsay Castro. Lindsay, as I'm sure you all know, she has wide experience in international arbitration, and her experience spans counsel and advisory work, as well as institutional service and academia. She's currently senior counsel at Arbitration Chambers, an adjunct professor of law at AU Washington College of Law. She has previously served as legal counsel at ICCA and as an attorney at Fresh Shields. She is also a CDR mediator and FCI ARB. We're very happy to have her with us today. On the same issue, we'll be speaking Panagiotis Chalkias, also known as Panos. Panos, a very important Young ICCA alumni, is an associate at YNK's International Arbitration Practice based in Geneva. His practice includes advising and representing clients in complex, high-value cross-border disputes in a variety of industries under all major arbitration rules, governed by various substantive laws, including common law and civil law. Lindsay Panos, the floor is yours. We're very interested to know what you have to say about the role of arbitral secretaries.
Thank you so much, Anna, and thank you also, Young ICCA, of course, everyone who is spending your really valuable time with us. We really appreciate it. So I think Anna's already explained that Panos and I are going to be having a conversation about the role of tribunal secretaries, and that following Garth's excellent introduction, this part of the workshop will be really focused on Article 3. And what Panos and I were thinking is that in the brief time that we have with you, we will try to cover a few different things. And the first is just really the content of Article 3, which Garth introduced. And then we'll go through, as he mentioned, there's a list of tasks in that article, and we'll sort of briefly go through all of those. And then second, we'll discuss how in practice, and I think everyone will agree with this, the role of a tribunal secretary can vary so much depending on just a wide range of factors. And so we'll touch on that. And then finally, of course, we will need to cover the current debate about, what tasks can permissibly be delegated to a tribunal secretary. And we'll refer to some of those cases that Garth alluded to. But I think, to put this all in context, we really need to think about what is the purpose of a tribunal secretary? Like, why are we there? Which some people legitimately ask, what are you doing there? And people have different answers to this, but I think we can probably all agree that, a secretary is there to add value and increase the efficiency of a proceeding. And the way that we do this is by assisting the tribunal, supporting the tribunal, and in many cases, we're carrying out tasks that the tribunal would otherwise have to do itself. And so I think that really brings us to the Article 3, the sort of general principle in Article 3.1, which is that, the guide tells us that the tribunal secretary's tasks, the role must go beyond the purely administrative, as Garth mentioned. And, of course, that's true, right? If you want to get the benefits, if you want to get meaningful efficiency gains, then the tribunal secretary is going to have to take on some meaningful tasks, right? And we'll be going through those in just a moment. So I think, starting from that premise is how we get to the list of possible tasks that we find in Article 3.2. And I don't know, Panos, did you want to maybe start with the first ones and go through some of those?
Yes, thank you, Lindsay. And also a big thank you to the Young ICCA co-chairs for the invitation and also for making this webinar possible. I have to say I'm very happy to be back at the Young ICCA event. It hasn't been a long time since I left the organization. And it's also great to be sharing this event with distinguished speakers and friends. So as Lindsay mentioned, Article 3 of the Young ICCA Guide sets out a non-exhaustive list of tasks that can be performed by tribunal secretary. I will deal with the first 5 of them, and then Lindsay will continue with the next 5. So the first task that is mentioned in Article 3 is undertaking administrative matters as necessary in the absence of an arbitral institution. I think this is an uncontroversial task, and it only comes into play if there is no arbitral institution administering the arbitration. One example of what this task may involve is, for example, monitoring and preparing the statements of fees and expenses of arbitrators, or monitoring whether the deposits with respect to the advances on costs have been made by the parties. The following task is communicating with the arbitral institution and parties. Again, I think this is not a controversial task. And it actually, for me at least, it means that if you have only one point of contact for the arbitral institution and the parties, this means that the efficiency of the proceedings will be higher. Then the third task is organizing meetings and hearings with the parties. Again, I'm not going to spend a lot of time discussing these first few tasks because they're not that controversial. But what I wanted to say, for example, with respect to this task is, of course, this task has evolved as the arbitration world has entered into this new virtual era. So whereas typically a tribunal secretary will go to the hotel conference room, check if there's enough space for all the arbitrators and their bundles, if the hearing bundle is already there, how far is it from the desks of the tribunal, are the mics already prepared, the audio system, is there a projector, is the projector working, and other various logistics. Now, typically what tribunal secretaries will do is they will liaise with the host of the virtual meeting or virtual hearing. They will liaise with the court reporter. They will liaise with the parties, with the arbitrators, to make sure that all the logistics related to a virtual hearing, which are a lot, have been taken care of. And of course, tribunal secretaries can also conduct a test run, which is, I think, advisable. So before the actual hearing starts, the parties and the tribunal secretary and the co-arbitrators can all participate in a test run to make sure that there are no glitches, the audio and the video are working perfectly. And these are, of course, a few examples of what a tribunal secretary can do when organizing hearings. Moving on now to the fourth task that is set out in Article 3, handling and organizing correspondence, submissions, and evidence on behalf of the tribunal. There's not much to say here. I think we will all agree, or most of us will agree, that making sure that the tribunal has easy access to every single document filed in an arbitration is of benefit for the parties and the process. Again, the tribunal secretary will receive the submissions of the parties throughout the submissions, and will have to figure out a system where the tribunal members, either online or via USB key, will be able to access basically all the evidence and all the submissions. And then coming to the fifth task, which is researching questions of law. Here, the majority of the survey participants agreed that this is an acceptable task for a tribunal secretary to perform, to the extent that performing legal research or completing, if you want, the legal research submitted by the parties can only lead to a better informed and grounded decision. Again, the point is not to say that the tribunal members themselves should not conduct their own legal analysis or legal assessment of the parties' authorities. But as we have mentioned before, the tribunal secretary's role is to support and not to replace. So yeah, I think I've covered the first 5 tasks, which, lucky me, are quite uncontroversial. And now we'll hand over to Lindsay for the next 5 tasks.
And please do chime in, because I realize that these are perhaps a little more controversial, but not the first one. Which what we have here is another research task, right? So Panos was just talking about legal research. This is a bit different because here we have looking into factual evidence and witness testimony. In other words, looking into the record, and this is something that happens all the time. I mean, first of all, perhaps some context. Often in cases, you have thousands and thousands of exhibits, 20 experts, 20 witnesses, this kind of thing. So oftentimes it's a lot to keep up with. And the tribunal might turn to the secretary and say something like, the witness makes assertion X, are any documents cited in support of X, or this kind of thing. So it can be very simple, or it could be more involved. We have next drafting procedural orders and similar documents. So I think we're going to hear a little more about this later in the workshop. So I don't want to spend too much time, but I will say that this is sort of bread and butter of tribunal secretary work. I mean, it happens throughout the proceeding. Different issues will need to be addressed through procedural order. From the very first procedural order, which sets out the whole the sort of procedural rules that will govern a case, to bifurcation, document production, and so forth. Now, interestingly, I think a majority of people agree that this is something that the tribunal secretary should do, right? But let's recognize that just because something is called procedural does not mean that it's not extraordinarily important for the case, right? So here is one where oversight guidance from the tribunal is very important. It is not that, the tribunal secretary is drafting the procedural orders and then just sending them out to the parties, right? This is really done under the guidance of the tribunal. We also see here the next task is that secretaries might be called on to review and summarize the parties' positions and prepare factual chronologies. So in my experience, and others might have a different experience, this usually happens in preparation for the hearing in large cases to help the tribunal come to the hearing with with having digested a large case record. And also, in my experience, this is extraordinarily time consuming. This can take a lot of work. And I see some smiles, so I know that others agree. This is what but it's also quite useful because some of that material, if it is created before the hearing, can then be used to help draft parts of the award later on. So we then get into attending deliberations. And I suppose in a way, this is a bit more controversial, but I would say that, a good secretary really knows their place, right? When we know that we're in a support role. And if you have just done all the tasks that Panos talked about and that I talked about, the chances are that you know the record better than anybody else in the room when it comes to deliberations. But it is not, for you to show off that knowledge or to share your views, or even sometimes to correct a statement that a tribunal member makes that you think isn't really reflected in the record, because it's really important not to influence the tribunal dynamics, right? But I think the secretaries does play an important role there with, again, finding things that the tribunal needs, putting things in front of them, and of course, recording the discussion. So there's a lot that a secretary can do, even if most of the time you're being quite quiet. And then finally, I'm not going to spend a lot of time on this one. It's drafting appropriate portions of the award. And I'm not going to also do air quotes, although I'm tempted for appropriate, because of course, what is appropriate? The views on that vary pretty widely. I think it's not controversial that a tribunal secretary would draft the procedural history aspect, the procedural history section. Most people agree that a tribunal secretary should be able to draft factual background and a summary of the parties' arguments. When we get into analysis section and legal reasoning, I think the majority view is that should be left for the tribunal, but not everybody thinks that. And we'll discuss this a little bit more when we get to the interesting sort of debate about what a secretary can and cannot be doing. But I think, so that we've just gone through all the tasks. So pretty much now we can end the workshop because we know everything that a tribunal secretary could do. But I think actually Panos is going to ruin that idea because he's going to tell us about how the role of a secretary varies quite a bit depending on different things.
Yes, so thank you so much, Lindsay, for covering the most controversial tasks. But I also wanted to say that we will be discussing later on the latest case developments, and we're going to see how courts have define the role of a tribunal secretary, and in particular, how they have dealt with the fact that some tribunal secretaries have drafted parts of the award. So yeah, for the moment, what we were planning to do is simply refer to the context of each arbitration case, which is very different. And this context can, of course, have an impact on the role of the tribunal secretary. So if we take, for example, if we have a look at the applicable arbitration rules, we will see that there is no overall consensus on how among arbitral institutions, on how we go about defining the tasks, the specific tasks of a tribunal secretary. And I will briefly mention two examples, the SIAC rules and the LCIA rules. And we will see that on the one hand, the SIAC practice note of February 2015 simply mentions that tribunal administrative secretaries can be appointed to assist tribunals in administrative matters, but it does not set out a list of potential tasks, and it does not provide that these tasks should be agreed between the parties and the tribunal. And my guess is that SIAC's policy is that these issues should be dealt with directly between the parties and the tribunal. But on the other hand, the LCIA not only provides for, it sets out a list of permissible tasks for tribunal secretaries, but it also provides that these specific tasks of the tribunal secretaries must be agreed between the parties and the tribunal. Otherwise, the tribunal secretary cannot be appointed. So we see here that there is a big difference between the two sets of rules. And as for the ICC, I think its approach is somewhere in the middle. So the ICC has an ICC note that sets out a list of permissible tasks for the tribunal secretaries, but it does not provide that these tasks have to be agreed between the tribunal and the parties. The ICC note also provides that if there is any doubt about what tasks can be performed by a tribunal secretary, the tribunal members or the secretary can contact the secretariats. Now, I have to say I haven't seen this in practice, and I wonder how many arbitrators have called the ICC to talk about the tasks of the tribunal secretary, but I guess this is just a rhetorical question. But what you need to keep in mind is that depending on what kind of set of rules you're facing, the scope of the tasks of the tribunal secretary can change. And this is something that we will discuss also later on when we will be referring to some case court judgments, which indeed considered the content and the importance of the rules of each institution in dealing with either set aside proceedings or challenge proceedings. So, and one, I think, additional point that Lindsay and I wanted to make is with respect to the co-arbitrators and the parties' input on the tasks, on the specific tasks that a tribunal secretary can perform. We understand that the appointment of the tribunal secretary will be discussed by a subsequent panel. But what I think we wanted to say is that it's, for us, best practice for tribunals to be fully transparent about the tasks of a tribunal secretary and set out and discuss with the parties the specific tasks that the tribunal secretary will perform upon his or her appointment, rather than just saying we are proposing to the parties to appoint Mr. X or Mrs. Y. We think that it's always better if the tribunal already comes up with a list of proposed tasks and give the opportunity to the parties to say we agree or we don't agree. And again, you will see later on that when we're discussing some court cases that the reason why, one of the reasons actually why it was possible to challenge awards on the basis of the role of the tribunal secretary is because the tribunals did not engage in that discussion with the parties. They didn't try to agree with the parties on the specific tasks of the tribunal secretary. So, Lindsay, I don't know if you have any comments or any input.
Well, I think just on what you were talking about with the institutions, there's sort of the guidance provided by institutions, and then also there's the practicalities of institutions as well. Something I know you're familiar with too. It's very, sorry if that's loud, there's a fire engine going by. There is certainly a difference between, for example, being a secretary on a case at the ICC, where the ICC is the institution, but they do not provide the same kind of assistance as, for example, you know, if you're lucky enough to have Garth on your case at the PCA, then Garth is going to do, as an institutional counsel, he may be appointed to assist the tribunal and therefore is taking over many of the tasks that otherwise in other contexts might fall to a tribunal secretary who's more employed by the arbitrator or brought on by a specific arbitrator. So having worked at ICCID, I know I always love when tribunals have secretaries or an assistant appointed to the case, because they make things easier, but it's important that they work together, you know, as if you're not part of the institution and you're brought on to assist the tribunal, you need to not step on toes, you know, work in concert, don't duplicate tasks, all of those things, of course, as I'm sure is obvious to everyone. But that's, and just one general point, which is that absolutely, I think the role of the secretary changes so much depending on the arbitrator for whom you're working or the tribunal for whom you're working. At the end of the day, I mean, that's really it. I would never think that an appointment for one tribunal should be, you know, will tell you very much about an appointment for a next tribunal, because expectations vary wildly depending on different things such as legal background, cultural background, and those kind of things. So just, you know, always expect the unexpected.
Yes, and just to follow up on what Lindsay said, in some cases you have arbitrators who are used to working with tribunal secretaries and they feel comfortable with the tribunal secretary assuming some of the tasks we have described. But in other cases, you have arbitrators that don't know the institution of a tribunal secretary, or they don't even know the institution of a judicial clerk because they're not familiar with this position based on their legal education, and they don't behave in the same way, and they don't all agree on what kind of tasks the tribunal secretary can be entrusted with. That's why what I said before, I think it's really important that you need to engage with the co-arbitrators and ask for their input before you decide to appoint a tribunal secretary, and to again discuss specifically the tasks that you're proposing the tribunal secretary to perform. Okay, so now I think, yeah, we're a bit running out of time, so I think we're gonna skip to the interesting part, which is discussing the latest case law developments. Lindsay, did you want to start?
Well, certainly, because I think we cannot have this. So maybe for context, I think we've been talking about the role of the tribunal secretary, and along the way we've mentioned some aspects, in particular award drafting, that are controversial. And I think Garth mentioned, and Panos has also mentioned, that this is an issue that's been addressed in the courts, and we just cannot start this conversation without mentioning the case that brought this to everybody's attention, which is, of course, the Yokosuki Russia case. And I know that many of you here today are very familiar with this case, and in the interest of time, I will have to oversimplify, so please forgive me, but just to give a sort of overview, this is the original arbitration in this case was seated in the Netherlands at The Hague. The tribunal issued, a hefty award against Russia, which Russia then challenged before the Dutch courts. And there were many grounds of the challenge, but one that caught a lot of attention, certainly for me and many others on here, I'm sure, was that it concerned the role of the tribunal secretary. And the argument was essentially, again, oversimplifying, that, the tribunal secretary had played this disproportionate role in the award and essentially acted as a fourth arbitrator. This word that this phrase I don't love, the fourth arbitrator. And so and because of that, they had, it was an impermissible delegation of power and also an improper constitution of the tribunal, right? Now, I won't go through the procedural history of this case, but the most recent decision came from the Dutch Court of Appeals, and the court upheld the award and therefore dismissed Russia's objection based on the tribunal secretary's role. And it's the essential finding, the heart there of this decision is that there was no evidence that the tribunal secretary had participated in the decision-making process, right? But I'm just going to raise two interesting points, and I'll leave it at that, which is, first, the court said, even if the secretary had drafted significant portions of the legal reasoning parts of the award, it is not that itself would not be annullable. It's not a problem as long as the tribunal has checked that for correctness, completeness, and taken responsibility of that draft. So that's one thing to keep in mind. And then the second is that the court did criticize the tribunal for not having informed the parties of the tasks that the tribunal secretary was going to take on. So I know I'm just rushing a bit because I want to give Panos a chance to provide us with some more recent updates.
Thank you, Lindsay. Yes, just to follow up on what you just said, that obtaining information about what the tribunal secretary has done or has not done is extremely difficult. It's a very it's almost impossible to obtain information as to what the tribunal secretary has done, given that the deliberations of the tribunal are secret. And what we have seen in at least 3 or 4 cases that were challenged is that the parties tried to obtain the time entries of the tribunal members and the tribunal secretaries and determine on this basis how much time each arbitrator spent on the case and how much time the tribunal secretary spent on the case, and then draw a conclusion from that. But that alone, for many of the courts, was not enough. And again, I think most courts in England, in Switzerland, now in Belgium, have said that even if the tribunal secretary has drafted parts of the award, that fact alone is not enough to prove impermissible delegation of decision-making. And I think that's the core point that so far all of the judgments have confirmed. And I just wanted to briefly go through the latest judgment that was issued by the Brussels Court of First Instance. So if the organizers can bear with me for 2 more minutes. I think this is a very interesting judgment. First of all, because it's very recent. The judgment was issued on 17 June 2021, so just a few months ago. And second, I believe it's the first judgment that deals with the ICC note and what the ICC note describes as permissible tasks for tribunal secretary. So this case relates to a 3-member tribunal case, and it was seated in Brussels, and the dispute related to the construction sector. And one particular aspect of this case is that the appointment of the secretary took place 1.5 months just before the hearing, which is kind of unusual because usually tribunal secretaries are appointed since the beginning, since the tribunal is constituted. So we can argue here whether this could have already hinted to what the tribunal secretary's role would be. But what happened in essence is that the tribunal issued a partial award, and the losing parties, after they received the award, they sent an email to the tribunal asking the following two questions. First of all, did the tribunal secretary drafted the list of questions for the experts that were asked at the hearing? And second, what was the role of the tribunal secretary during the preparation of the partial award? And all three arbitrators, they responded individually, and they all said that there was no impermissible delegation of decision-making, and that the award was the product of all three arbitrators, of their decisions and of their deliberations. However, the tribunal president admitted that the tribunal secretary had drafted the list of questions for the experts and had also participated in the preparation of the partial award. And following this disclosure, the losing parties, they made 3 document production requests. They basically asked for the time entries, they asked for the drafts of the list of questions that were prepared by the secretary, and the drafts of the awards. And what is, I think, unprecedented here is that the tribunal president resigned because he felt he was no longer impartial vis-a-vis the parties. And he noted that the requests that were made by the losing parties were, and I quote, unprecedented, unacceptable, and aggressive, something like that, yeah. And the ICC accepted the resignation of the president, which meant that the document production requests could not be granted. And also the tribunal secretary, as a result, had to resign. And the Court of Brussels had to decide the challenge on the setting aside of the award on various grounds, including the role of the tribunal secretary. And the Brussels court looked at the ICC notes, and it looked at the list of tasks that the ICC sets out in paragraph 224. And the court said that if you look at the tasks, you can assume that the tasks of the tribunal secretary will not only be administrative and will go as far as drafting awards. So in a way, the court said that by choosing ICC arbitration, the parties had consented to the tasks of the tribunal secretary going beyond the administrative. Another point that I think is important is that the court looked at the CV of the tribunal secretary, and in particular, it looked at one conference or training that was organized by the ICC, and that was focusing on drafting enforceable awards, and it was addressed to tribunal secretaries. So the court immediately said, again, this is a clear sign that the tribunal secretary was going to be involved in the drafting of the award. And long story short, the ground was dismissed because, as we said before with Lindsay, the fact alone that the tribunal secretary participated in the drafting of the list of questions or in the drafting of the award didn't mean that there was improper delegation of decision making. And actually, the court looked at the statements that all arbitrators made, where the arbitrators all said, we reviewed every single sentence, we reviewed every single footnote of the award, and the court considered that this way of agreeing the partial award and working with the tribunal secretary was acceptable. So for me, at least in my opinion, this is the court has taken quite a liberal approach, but also very pragmatic. But again, this is a decision that can be challenged, it can be appealed, and it remains to be seen if the Court of Appeals of Brussels will take a different path. So I think this concludes our presentations. Thank you so much for your time, and I look forward to the following panels.
Thank you, Panos. Thank you, Lindsay. This is indeed a very interesting topic that raises a lot of questions. And we look forward to hearing from some of the things that you've mentioned already in the next panels. I'll just remind everyone, we already have a couple of questions. Really do feel free to write down whatever comes to mind regarding the various issues that we'll be addressing. There's a Q&A section in the end, as is programmed. So we'll make sure that we get to as many as we can by the time we get there. This is for all those joining us, participants and panelists alike, of course. Well, having said that, we now come to another section of what we wanted to discuss regarding arbitral secretaries, and that is going deeper into the practicalities and costs regarding appointments of arbitrators. And to speak about those things, we have two amazing panelists as well. Francisca Ciara Cardoso, associate at Armesto y Asociados, based in Madrid. Francisca is a Portuguese lawyer specialized in commercial law and arbitration. She acts as secretary to the Arbitral Tribunal, currently at Armesto y Asociados. Before joining this firm, she worked as counsel in the arbitration and litigation practice of the Portuguese law firm Moraes Leitão. Side by side with her, we will have Dr. Reika Pap. Reika is counsel at the office of Pierre Tercier, where she acts as secretary in international commercial and investment arbitrations. Before joining the team of Professor Tercier, she was a senior lecturer at the MIT Geneva LLM. While living in Vienna, she also worked as an associate at a law firm in the field of international commercial arbitration and energy law. So here you have it, two excellent professionals who will be digging into these topics. And we look forward to listening to them. Thank you, Francisca and Reika. We're happy to have you here.
Thank you very much, Anna. I will be the one starting the discussion, which is why I'm jumping in. I hope you can hear me and see me well. Wonderful. So I will be starting with the practicalities around the appointment of arbitral secretaries. What do we mean by practicalities? It is essentially what is in Article 2 of the Young ICCA Guide on Arbitral Secretaries. So if you have not yet opened it, now would be the time, because I will be dealing with the issues in the same order as this article, so that you can always go back and refer to it. I will start with the very crucial question of who proposes the candidate, who puts forward a name for the arbitral secretary. Now, quite naturally, it will be the Arbitral Tribunal. On the one hand, because of what the guide also says, that the Arbitral Tribunal is basically the best place to know whether a case is well suited for the appointment of an arbitral secretary, but also because the arbitral secretary, as pointed out by the members of the first panel, will be closely working together with all the members of the Arbitral Tribunal. So there is this question of trust as well, that of course they have to trust this person and trust her or him with the important tasks. Now, when it comes to a three-member tribunal, it is usually the president of the Arbitral Tribunal who puts forward a name or suggests a name first to the co-arbitrator. So there is always a consultation with the co-arbitrators. I have personally never been in a situation or heard of a situation where the president insisted to put forward the name against the will of the co-arbitrators, which would anyways be quite strange given the close working relationship with all members of the Arbitral Tribunal, since the secretary serves all of them at the end. Now, when proposing a candidate to the parties, there's a list of documents that one has to send together with the name, or it's general practice to send together with the name of the candidate to the parties. And in some institutional rules, there is a list provided, for instance, under the Hong Kong rules, but generally one sends the CV of the candidate, a statement of independence and impartiality, as well as a description of the tasks that the arbitral secretary will carry out. And I refer back to the discussion of the first panel, where I think Lindsay said how important it was to be transparent, that this is the moment to show the parties the transparency and tell them this is what the tribunal secretary will do. And after what I have seen, this is also the moment when arbitral tribunals prefer to underline that they will not delegate any decision-making functions to the secretary. Now, when it comes to the CV, I'm not going to spend a lot of time on that. You all know how to do a short, to the point, maximum 2 pages long CV that should showcase your experience, why you're suited, obviously, to the task, but also your professional relationships, which will be important in relation with your statement of impartiality and independence, to show the parties that you are capable to be impartial and independent. And why do you have to show that to the parties? It's because of what also the guide says, by the way, expressly says, but that is also generally accepted and even spelled out specifically in some major institutional rules, such as in the ICC rules, is that arbitral secretaries have the same impartiality and independency obligations throughout the proceeding as arbitrators. And this is why, obviously, it is crucial for the parties to have as much information as possible, relevant information about the arbitral secretary's background. The guide also suggests, and I think it is an excellent suggestion, to refer to the 2014 IBA guidelines on conflict of interests to see what facts or relevant circumstances the arbitral secretary should disclose that could give rise to justifiable doubts. The IBA guidelines expressly say that they apply to tribunal secretaries, by the way. So this is a very good benchmark, a standard to apply. Here comes, of course, the other important question is whether whose responsibility it is to ensure that the secretary remains impartial, and it is and remains throughout the proceedings impartial and independent. Now, the guide tells you that it is incumbent upon the arbitral tribunal to ensure independence and impartiality of the secretary. This view is shared by several institutional rules, possibly mostly impliedly. But I would say too that it is good to be cautious, because other institutional rules would require the secretary personally to submit all the statements of independence and impartiality, and would talk about the secretary's obligation to remain independent and impartial. So the onus there might be on the secretary. For instance, in Singapore or under the Singapore rules or the Hong Kong rules, I would say in any event, it pays off to be proactive. And if any circumstances should arise or are there that could give rise to justifiable doubts under the IBA guidelines, I would definitely share that with the members of the Arbitral Tribunal and see how to proceed after that. I also wanted to add that together with the CV and the statements of impartiality and independence, some institutional rules will even require a statement of availability from arbitral secretaries, just as from arbitrators, for instance, the Hong Kong rules, or a statement of confidentiality, the Singapore rules, and I will come back to the issue of confidentiality. Now, having received all these documents, the parties will now have the opportunity to see whether they agree with the appointment of that specific person proposed or suggested by the arbitral tribunal, or they might make reasoned objections against the appointment of that person. Now, the Young ICCA guide will tell you that the arbitral tribunal may proceed with the appointment despite objections from one party. And other rules or other institutions share this view, for instance, the Hong Kong International Arbitration Center, but also the Stockholm Chamber of Commerce, where challenges against arbitral secretaries based on lack of impartiality or independence are decided by the board of the SCC, just like in case of the arbitrators. But here, it is even more important to be aware that several major institutional rules expressly require the agreement of both parties for the appointment of a tribunal secretary. For instance, the Singapore rules, ICC, LCIA, AAA, or the ICCID when it comes to assistance to arbitral tribunals. So this is very important to keep in mind, I would say, but I would also like to add that I have never heard of an instance where the arbitral tribunal has appointed a secretary against the parties or one of the parties' will. And it would be very interesting to hear from any panelists or anyone who's participating who has experienced such a case. And I would also wonder what happens in an ad hoc arbitration or in an institutional arbitration where the institutional rules are absolutely silent about arbitral secretaries, which is actually, after my research, it is often the case in regional arbitration centers, whether the arbitral tribunal's procedural powers go as far as to allow the arbitral tribunal to appoint a secretary despite the objection by the parties. It will probably depend on the objection, what is the objection about, and what tasks the secretary will carry out. But it would be an interesting thing to know. And finally, I wanted to tell you that the arbitral secretaries share the same obligation of confidentiality as the arbitrators. And this is, again, there's wide consensus about it. You will find it in several major arbitration rules. But in exchange, they also benefit from the same immunity or exclusion of liability. Once again, wide consensus on this issue as well. So to sum up quickly, I would say that since it is the arbitral tribunal that puts forward the name of a candidate, if you want to become a tribunal secretary, it pays off to work closely with lawyers who act as arbitrators, obviously, but I've also heard of instances where law students or research assistants to professors who act as arbitrators have received a secretary appointment, and also have a short but informative CV, which you be prepared to fill out a statement of independence and impartiality by referring to the IBA guidelines, 2014 IBA guidelines, when it comes to the circumstances you should or should not disclose. And yeah, rest assured that you have the same obligations when it comes to impartiality, independence, and confidentiality as the arbitrators, but you benefit from the same immunity and exclusion of liability. That is all from my side. Thank you again for listening, and thank you very much again for the organizers of this workshop for having given me this opportunity. Thank you.
Thank you, Rika. So before starting my presentation on Article 4 of the Young ICCA Guide, I would also like to thank the Young ICCA for the invitation and for organizing this amazing event. So Article 4 of the Young ICCA Guide concerns the costs of arbitral secretaries. And Article 4, Section 1 establishes the starting point, which is that as a general principle, the use of an arbitral secretary should reduce rather than increase the costs of the arbitration. So the idea is that the work of the secretary helps the parties to pay less than they will normally pay, because arbitral secretaries can do a lot of work that the tribunal will otherwise have to do at a higher cost. And as mentioned before, this is one of the main reasons to use arbitral secretaries. Moving forward to Article 4, Section 2, it addresses basically three main principles of fairness, proportionality, and transparency, and contains two main ideas. The first idea is that the remuneration of the arbitral secretary should be reasonable and proportional to the circumstances of the case. So, as Reka mentioned before, the arbitral secretary assists the arbitral tribunal, and therefore the arbitral secretary's remuneration is usually proposed by the arbitral tribunal based either on an hourly rate or a fixed amount, lump sum, as appropriate. But what does reasonable and proportional mean for tribunal secretary's fees. And the tribunal proposals should take into account, first of all, the circumstances of the case, mainly the amount in dispute, the project length of the arbitration, the complexity of the issues in dispute. Another factor could be the experience and knowledge of the arbitral secretary. All depends on the circumstances, but on average, the 2013 survey indicates that an appropriate range will span from $125 to $225. Also, on a basis of a recent survey among tribunal secretaries, the hourly rate will be in euros from 125 to 300 US dollars, and 125 to 175 euros, as others indicated. Another thing to add is that the fees may also be bound to those of the tribunal, for example, at a rate of 1/3 of that paid to the president of the arbitral tribunal. This percentage may vary from a range between 20%, 33% of the rate of the president of the tribunal. The second idea of Article 4, number 2, is that the remuneration of the arbitral tribunal should be transparent from the beginning of the arbitration. So the proposed fee schedule should be provided to the parties at the very outset of the arbitration, at the time the candidate is proposed, and it's subject to the agreement of the parties, which the parties can object and also propose an alternative fee for the secretary. Another way to ensure transparency, as was mentioned before, is to disclose the tasks that the arbitral secretary will perform, and this should be disclosed at the very beginning of the arbitration as well. Moving forward to Article 4, number 3, it speaks of the manner of payment of fees on the one hand and the reimbursement of costs on the other. And it depends on how the tribunal is remunerated. So either on the basis of on the amount of the dispute, as it happens with most ICC cases, for example, or on an hourly basis, as it happens for exit cases, for example. And according to Article 4, number 3 of the Young ICCA Guide, if the tribunal is paid on the basis of the amount in dispute, then the secretary should be paid from the tribunal's fees, rather than having the parties paying for those costs. While if the tribunal is paid on an hourly basis, then the secretary should be paid directly by the parties at the specific hourly rate agreed, due to the inherent time and cost savings associated with the use of an arbitral secretary. This is also useful to avoid having the hours of the tribunal secretary included in the hours of the president of the tribunal. There could be a temptation to include the secretary's fees in the fees of the president of the tribunal, and this can lead to the nullification of the savings that have to be achieved through the use of tribunal secretaries. Therefore, having separate fees, one from the tribunal, the president, whatever, and other for the secretary, could lead to lower the costs, and it also makes the process more transparent in the end. Retainer fees are also an option. The arbitrators or the parties may pay for the secretary's availability. As far as I know, this is not so common, and it doesn't mean that it's good or bad. It depends on the circumstances of the case. And finally, it is generally accepted that the parties cover the justified, reasonable personal disbursements for attending hearings or meetings, like the cost of the hotel, taxis, food, and so on and so forth. Nevertheless, this also should be agreed with the parties at the very outset. So to sum up, the remuneration of the arbitral secretary should be reasonable and proportional to the circumstances of the case, and should be established at the very beginning of the arbitration to ensure transparency and also to guarantee that the use of arbitral secretaries fulfills one of its main purposes, that is to reduce the costs of the arbitration.
Thank you, Francisca. Thank you. Getting into the details makes it, much more interesting. And I was paying very close attention to what you were saying. Well, assuming that both you and Reka have presented to the fullest, I thank you. This is really, really interesting to see how things can work in practice and how different principles of being transparent, being cost efficient, being collaborative, making sure everything is right there from the outset on the table, how these things should be considered and how to consider them really in practice, how it all works. Thank you so much for your contributions and for being here with us today. Having said that, we turn to the next two panelists that will join us. And from whom we cannot wait to hear from. So talking about the general best practices for arbitral secretaries, we will have Niusha Vasili, a partner at Henrysio and Vandenberg. Niusha has acted as counsel and arbitrator in numerous international arbitrations and enforcement and setting aside proceedings. She regularly publishes and speaks on novel matters concerning international arbitration. Nisha also teaches, specifically the New York Convention at the University of Miami, Meads, and the US. I'm also aware that Nisha has very close ties to this Young ICCA Guide, so we're very happy to have her with us here today. Joining Nisha will be Eugene Thong. Eugene serves as tribunal law clerk at the arbitration chambers in Singapore, where he is involved in both commercial and investment arbitration cases. He was previously deputy counsel at the ICCA, both in Hong Kong and in in Singapore, and has also worked in private practice in Singapore and London. He's educated in both civil and common law traditions and speaks English, Mandarin, and French. Niusha and Eugene, we very much look forward to your contributions, and the floor is all yours.
Thank you very much, Anna, for this very kind introduction. Thank you very much, Young ICCA, for this fantastic event and for inviting me to speak along this great panelists. I am indeed very honored to be here because this is a topic and a matter very close to my heart, as Anna already pointed out. And when Garth was talking about the guide, it brought back very nice and fond memories about the drafting and how we actually turned around many words upside down, looked at what could be feasible, and we thought we were very brave to put this all into this guide as best practices, and in particular the provision about drafting appropriate parts of the award. I think we thought very long about it. Lindsay already hinted to it what that might mean, but we left it open for interpretation. So I'm happy that it has seen the light of the day with a little bit of a delay, because the draft best practices, at least, were already put in on paper even before ICCA 2012. So it's actually a 10th anniversary. The publication then came later of the entire guide. So I'm very pleased to talk about the general principles on the appointment and use of arbitral secretaries with Eugene. And what Eugene and I have thought about the presentation of these general principles is to show very briefly only the Article 1, just to have everyone focused on the main provisions. We will discuss these provisions, we will rotate, and we have also some output. So we will talk about these 6 provisions in Article 1, but then also make some suggestions. And here we see the text of Article 1. So I will now deal with Article 1.1, which provides that an arbitral secretary should be appointed to support an arbitral tribunal where it considers that such appointment will assist in resolving the dispute effectively and efficiently. So obviously the words effectively and efficiently are the key words here, because we see a development already. We saw it about 10 years ago. We see it even further, that the cases are becoming more complex and the number of counsel are becoming more numerous on both sides. So with that, there should be also an appropriate assistance to the tribunal, and not only, by the way, to the one chair, but to the entire tribunal. And therefore, it is, as a general principle, indeed, to take the threshold at, is it efficient and effective to appoint a tribunal secretary or not? And that's why the wording as well has been put as if it considers it, that such appointment will assist. So the dispute. So that's why there is discretion, obviously, and not every case warrants for a tribunal secretary. In particular, the cases that you all are working on as a very junior or have worked as a very junior arbitrator. So indeed, in fact, also the institutions that would naturally appoint you as an arbitrator would probably expect that you would do it on your own without the assistance of a tribunal secretary at the beginning. So this is so much to say that there should not be a blanco decision always already assumed and presumed that a tribunal secretary would in fact make the case more efficient. But indeed, I would say the majority of the cases benefit nonetheless. And I just wanted to point out that I'm not necessarily looking at the amount in dispute. It's more about the complexity of the matter. And so that makes a big difference. Then I should also say that I suggest the use of tribunal secretaries frequently when I'm appointed as an arbitrator, and we will come to that point. There have been also objections to that appointment, and then it didn't happen. But I will now give the floor to Eugene to talk about Article 1.2, and then we'll take over again.
Right. Good morning, afternoon, or evening to all, wherever you are. So thank you, Nusha, and to the organizers. Now I'll move on to Article 1.2. And the text of Article 1.2 is, an arbitral secretary should only be appointed with the knowledge and consent of the parties. Now here, the principle is relatively uncontroversial. An arbitral secretary should be appointed with the knowledge and consent of the parties so that the arbitral process remains transparent. For those of you who are not familiar with the guide and its articles, there's actually a running commentary as well. So as the commentary states, this article originally arose due to concerns raised that there are arbitrators who are, and I quote, habitually assisted by arbitral secretaries without any formal appointment process, or in some circumstances, without identifying these assistants to the parties. Now, from my experience, this actually does still happen. For example, we can see that happening when an arbitrator requests for someone else to be copied on emails. And presumably when this happens, this means that that person is assisting in one way or another on the case, though we are not sure how and how exactly and to what degree. So parties may not even be aware of such assistance if the person is not, for example, copied on emails. And hence, notwithstanding that the present situation is probably better than it was previously, let's say when the guide was first published, this principle is still very much important because it remains the bedrock principle from which best practices flow and also to which we all still aspire. Now moving on to Article 1.3, the text reads, an arbitral tribunal should notify the parties of its intention to appoint an arbitral secretary at its earliest convenience. And this article is also not that difficult to understand. The idea here is to avoid delay in notifying the parties of the intention to appoint an arbitral secretary. And as stated in the commentary, the recommendation here is to firm up the appointment of the arbitral secretary by the first procedural meeting or by the issuance of the first procedural order if there is no such meeting. This accords also with my experience in my current role when I'm appointed as arbitral secretary in cases. For ICC arbitrations, as some of you may be aware, there is also a document that often accompanies, in fact, no, it must accompany the first procedural order, and that is the terms of reference. And for the benefit of those who might not be familiar with the terms of reference, this is essentially a document, a contract actually, between the tribunal and the parties, setting out the framework within which the arbitration will proceed. And for example, it discusses, it indicates the place of arbitration, the language of arbitration, the governing law, and other such details. And importantly, it also lists the issues that are to be determined in the arbitration. So in this document, relevant details of the appointment of the arbitral secretary should also be included. And in fact, if you actually Google online, you'll find that there is a model or template terms of reference available online on the ICC website. And in this model or template document, you'll find that there are paragraphs relating to the arbitral secretary as well. So that is all from me for Articles 1, 2, and 1.3. And now I'll hand you back to Nusha.
Thank you very much. I will deal with Articles 1, 4, and 5. And this comes actually close to the crux of these court decisions that Panos and Lindsay were referring to, because in Articles 1, 4, and 5, they provide that it is the responsibility of each arbitrator not to delegate any part of his or her personal mandate to any other person, including, of course, the tribunal secretary, and that it is also the responsibility of the arbitral tribunal to appropriately select and supervise the tribunal secretary. So, first of all, you have heard of this term probably already, intuiti personae. It is a mandate of the arbitrator, meaning that they should themselves carry out the work and especially the decision making. The decision, in particular, the second one that Panos was referring to, I had no dealings in that, was a court decision of the Brussels Court of First Instance. And it was quite interesting indeed to see to which extent what is necessary basically for a court to say that there is a delegation of decision-making powers. And we can only deduct, I think, from that decision in particular, what it could be. So there was a time when people were saying then about this decision in particular, oh, okay, as long as the tribunal actually signs the decision, then it's fine. That means that the arbitrator, the tribunal members, they have already reviewed it, and that's good enough. Now, it's really when it comes to the lack of supervision, which I would coin as a user's problem, meaning the user is the arbitrator or the tribunal. That's when it comes to the unduly delegation of the decision-making power, and it has indeed, I think, by now been rooted out. If ever this practice was present, I don't think so, and I don't think you can call it a practice at all. If it happened, that it was really occasionally, but not that not something that has occurred on a regular basis or anything. What the guide, however, wanted to make sure is that whenever a tribunal wants to make use of a tribunal secretary's assistance, then A, it's the tribunal's own responsibility, and B, the supervision of that tribunal secretary is key. Only then we can talk about a use of the tribunal secretary. Everything else would be abuse. And we should also put ourselves, especially since we have so many young people in the audience, it's a lot of responsibility that a tribunal secretary might be put on if suddenly the tribunal, the arbitral tribunal says, this is it, so you're now in charge, go for it. So obviously this cannot be, you're not made for that, and this was never your role. And I would encourage everyone to say, no, stop, I cannot take over the decision-making. So that is still your job, and protect yourself. Having said that, it's with that responsibility of the tribunal, there comes also the downside of challenges, of course, and there have been a number of challenges, as we have heard, about delegating the decision-making power to someone else who was not appointed by the parties as an arbitrator. So I think this is one of the key principles in the appointment of the tribunal secretary. So go back to the user. Who is the user? The user is the tribunal, or if it is a sole arbitrator, the sole arbitrator. Eugene, back to you.
Hello, everyone again. So back to me, it's Article 1.6. So the text of Article 1.6 reads, where an arbitration is proceeding under institutional arbitration rules, any rules and policies of the institution relating to arbitral secretaries shall apply. Now, this article is relatively straightforward, but I would still like to draw your attention to several points in this regard. Firstly, as alluded to earlier by previous speakers, a few institutions have their staff members act as arbitral secretaries, such as ICCID, the PCA, HKIAC in Hong Kong, and also for those of you who are more familiar with this region, CTEC, which is the one of the main Chinese arbitral institutions. So in such arbitrations, the situation may be slightly different in that any additional assistance from, say, an associate in the arbitrator's law firm will have to be adjusted according to the relevant institutional setup. For instance, on ICCID's website, you'll find that they mention the use of what they call tribunal assistants, which is the role that, for example, I would play in an ICCID case, which is a separate role from the tribunal secretary, which is an ICCID staff member. Another matter to be aware of is that institutions often issue notes providing guidance on the subject of arbitral secretaries, again, as has been alluded to previously. Sometimes these notes cover a broad range of issues relating to the entire arbitral process, such as for the ICC and LCIA, and at other times they address the topic exclusively of arbitral secretaries, such as for HKIAC and SIAC in Singapore. Generally, though, they agree on the overall approach to take regarding arbitral secretaries, though there may be certain key distinctions in specific areas. For example, the process for removal of an arbitral secretary, if it comes to that, unfortunately, may not be the same. For the LCIA, for instance, you'll see in its note that it makes references to the LCIA rules, including provisions on challenging the tribunal secretary himself or herself, which does not feature in all the other, in the notes of the other major institutions. Another important difference, for example, is the remuneration structure, which has been mentioned by other speakers as well. And it is in some sense tied to, or it kind of runs parallel to the fee structure of the tribunal itself. So that is all that Nusha and I have to say about the article or the text of the article itself. we thought it would also be useful and interesting to discuss for a bit the present situation and also issues that might arise in the future, given that the guide was issued quite a number of years back. So the following is meant more as points for discussion and even just to be a bit controversial, to push the discussion a little further, which also means that we may not have the answers ourselves, by the way. So earlier, I mentioned that there are arbitrators who are assisted by secretaries who are not formally appointed or even identified to the parties. An issue that flows from this is that in the case of 3-member tribunals, the arbitral secretary will usually be someone selected by the presiding arbitrator, of course with the agreement of the co-arbitrators as well as the parties. But then in that case, what happens to the people or the persons assisting the co-arbitrators if the co-arbitrator is indeed being assisted by someone else as well? No doubt, I am aware that any assistance rendered to the co-arbitrator by an associate in the same firm will likely be peripheral, because most of the relevant tasks will be done by the presiding arbitrator's assistant or the tribunal secretary, so to speak. It might be that this issue then turns out to be moot because the impact or implications in reality are minimal or even zero. But even so, if we take transparency as the starting point and fundamental principle, then this question is still worthy of reflection. And indeed, I'm glad to say that Nusha will also follow up on this point in her remarks later on. Now, the next angle I wanted to explore the subject from is the differences between the different institutions. One thing I noticed while I was going through the various institutional notes on the subject is that different institutions require different sets of documents to be circulated to the parties prior to the appointment of the arbitral secretary. For example, while most of the major institutions require the secretary's CV to be circulated, the LCIA actually does not, at least not in its note. Or another instance is the HKIAC, which mentions the issue of availability in its note, but this isn't the case for other major institutions as well. So I thought that maybe this would be an area that might end up being more standardized as time goes on in the future, even to the point that there might be some sort of more or less standardized form issued by institutions that the arbitral secretary will have to complete and circulate. And probably from the looks of it, this form will likely cover issues relating to availability, impartiality, independence, confidentiality, and disclosures if there are any. And of course, also accompanied by the CV itself. And moving on, the last issue I thought I'd mention also relates to standardization. While talking about the subject with a colleague of mine, she mentioned that she saw in a case once that the arbitral secretary's name was actually indicated on the front sheet of a procedural order after the names of the arbitrators. So again, for the benefit of those who are not familiar, who might be more junior. So usually in these important documents in the procedure, there's usually a cover page with the case name, the parties, and then the arbitrators' names. And at least from my experience in this part of the world, it's not all that common for the arbitral secretary's name to be included on the front cover page. But apparently this has happened in one of the cases seen by my colleague. And the arbitrator in that case, in case anyone was wondering, is known to be pretty solid in his or her work. So he or she must have thought through the matter properly before deciding to do so. And so this does strike me as a practice that is worthy of consideration, not least, of course, because it boosts transparency. And in fact, while I was thinking about it earlier, actually, it's actually done for exit cases as well, notwithstanding that the arbitral secretary in those cases will be an exit staff member. And finally, before I hand the floor back to Nusha to answer Panos's question, because he kind of raised the question earlier as to whether the ICC receives many questions regarding arbitral secretary matters. From my experience, when I was with the ICC, this was not common at all, if that is reassuring in any way. So those are all the points that I thought I'd mention. Back to you, Nusha.
Thank you very much, Eugene. I have 2 points. One is a suggestion and one is a question. First, my suggestion, I would ask Eugene to share his screen again, please, with a text that I use often when I think that in this case it's appropriate to have actually assistance by a tribunal secretary. And this is a text that is in fact based on the best practices of the ICCA guide, and which I would normally, if I'm the chair, first circulate amongst my co-arbitrators, whether they're fine with it or not, after they have given their preliminary okay to consider appointing a tribunal secretary, and then to send this text to the arbitrators, to the parties to seek their consent. And as Panos already stated, and as Eugene also in reference to Article 1 stated, this should of course come before and as soon as possible, and before any action that the tribunal secretary would take. Now, this text has sometimes, as I said already before, been objected to, and I still suggested then in consultation with my co-arbitrators to the parties that maybe certain tasks should be stricken from the list or amended. So you can basically have a tailor-made setup of what exactly tribunal secretary that would be appointed by consent of the parties would take care of in terms of the tasks carried out. Where I'm also perfectly happy to share this slide later on with the panelists, but this is something that I wanted to point out. And the second point is food for thought. Just a couple of days ago, on the 22nd of September, ICCID and Uncitrol released a third version of the draft code of conduct for adjudicators in international investment disputes. And interestingly, the first article refers to all kinds of players. Adjudicator means arbitrator or judge. Arbitrator means this. Candidate means that. International investment dispute means X, and judge and treaty party means Y. Assistant is the third point. An assistant means a person working under the direction and control of an adjudicator to assist with case-specific tasks as agreed with the disputing parties. What's missing? The tribunal secretary is missing from this list. You can access this draft code of conduct on iccidworldbank.org's website, or just type in Google the draft code of conduct of the ICCID and Uncitrol, and you'll see this. So I just wanted to say that there is a lot of room for nuance left, that you can comment on these drafts, on this draft. And I wanted to encourage everyone who is interested in this topic to indeed send your comment on this draft to the email provided for, because it is quite short-sighted, if I may say so, at this very moment. And I understand it's a draft, but it's already the third draft, that only an assistant is mentioned, but not the tribunal secretary. And it's the assistant only to one arbitrator. So it's not talking about the assistant to the tribunal, meaning to a panel of 3. No, it's only to one. So get your thoughts together. Send your comments in, and I'm sure ICCID and Uncitrol will like to hear, especially from the younger generation, because it affects especially the younger generation as well. Thank you very much. Over to you, Anna.
Thank you, Nusha and Eugene. It was a pleasure to listen to your very coordinated arbitration ping pong. and thank you for giving us this very almost an authentic interpretation, coordinated from regarding both the guide and the rules that we so often work with. I think this was incredibly helpful, and actually ties very well with the next step of this event, which will be a walkthrough of the steps in an arbitration and a discussion on the various tasks of an arbitral secretary. And to provide us, to take us by the hand through this walkthrough, we have three amazing speakers. So first, we have Crystal Batista, who is an independent arbitration practitioner based in Madrid, who works as an arbitrator, as a freelance tribunal secretary, and also as a consultant. Crystal takes part in commercial and investment arbitration proceedings under the main international rules. She has served as counsel, tribunal secretary, or arbitrator in cases arising from construction projects, shareholders agreements, joint venture agreements, real estate, gas pricing, financial services, and other contractual disputes, as well as in investment arbitrations. With her, we will have a very interesting pair. Ibifubara Perenibara, who is a partner at LawQ Legal, a firm of lawyers based in Nigeria. He advises corporate and private clients on complex commercial issues and represents them before the various levels of courts in Nigeria. He's a fellow of the Chartered Institute of Arbitrators and a notary public of the Federal Republic of Nigeria. Very nice to have you with us, Ibifubara. And last but not least, we have Raul Donde, who is counsel at Levy Kaufman Kohler in Geneva. Raul has acted as arbitrator, counsel, secretary of the Arbitral Tribunal in over 30 international arbitration proceedings, both in ad hoc and institutional cases. He has worked in Switzerland and India for several years and has expertise in high-value, complex commercial disputes in both common law and civil law systems, and is also, of course, a very esteemed member of the Young ICCA events team. The floor is yours. We are happy to follow you through this journey of what it is that an arbitrator, tribunal secretary does. You have the floor.
All right, thank you so much. My colleagues and I, Rahul and Crystal, will be going through, may take you through the process, the appointment and duties of the arbitral secretary. Interestingly, other panelists have discussed virtually everything, but what we're trying to do is just to take you through from the beginning to the end. Let's say from the point of appointment up to at the award and maybe thereafter. So basically, just as has been heard before, the first thing that will be considered once the tribunal is appointed, either the sole arbitrator or maybe when the chairman or the presiding arbitrator is appointed, is to determine whether or not he will need an assistant. So is there a need for him to get someone to be doing some procedural things, or he can take it through without requesting or requiring anybody's assistance? So that is necessary, and for him to do so, he has to look at it from the very, very earliest period of his appointment. So, and if the tribunal now believes or thinks that there will be need for them to have an arbitral secretary, then they have to notify the parties and try to seek the consent of the parties in this regard. And then what then happens? At what point will that be? The question is it before the first meeting or procedural meeting is held, or at the first procedural meeting? So the way I look at it is this. A sole arbitrator, once appointed and believes and thinks that he will need an arbitral secretary, would have maybe in accepting his appointment also notify the parties that he will need an arbitral secretary. That is one way he could do so. The other way is, once appointed, after he had accepted his appointment, he may seek the parties' consent for him to appoint an arbitral secretary. Otherwise, it is in the first procedural meeting. Whichever way, as far as he's seeking the consent of the parties, he has to provide the parties with every necessary documentation or tools for them to come up with an informed decision. And what are those tools? It could be the CV of the proposed the arbitral secretary, and the independence, impartiality, or the of the arbitral secretary for the parties to consider and think whether or not there is need for them to accept the arbitral secretary in that particular proceedings. But it is not for the parties to accept just for the asking. The people, for certain reasons, say they do not need an arbitral secretary. And what are the reasons? It's possible that the person that has been proposed to them as an arbitral secretary could be conflicted, in the opinion, could be conflicted. And if that is the case, they would have to raise the issue before the arbitral tribunal. Also, it's also possible that they will feel that the amount or the sum that could be incurred in appointing or having an arbitral secretary will be too much for them. So there will be no need for them to have an arbitral secretary, and they will believe that the tribunal should carry out.
Well, I'm unsure if is it only me, or maybe Bifubara had a glitch.
While we wait for Bifubara to join, and I hope he can join relatively soon, let me proceed in the interest of time. I do understand that we're running a little bit late. So first, I wanted to thank all of the organizers for inviting me to speak, and for the excellent organization of this session. I think it's going really well, and I have learned many things. I've taken notes as well. So thank you very much. I think all of the speakers preceding me have been excellent, and their presentations have been very good. The role really that we are fulfilling now is to describe to you in some greater detail what you can expect, what tasks you can expect an arbitral secretary to perform once an arbitration has commenced. So Bifubara was talking about everything that the secretary is expected to do up until procedural order number 1. And I'm going to carry forward from there, and I'm going to talk about the tasks of the arbitral secretary from procedural order number 1 until the hearing, until the first substantive hearing, the first oral hearing. And Crystal will talk about the oral hearing, the award, and thereafter. So in the main body of the arbitration, let's say, what tasks can you expect a tribunal secretary to perform? Before I delve into those details, I did want to mention just 3 preliminary points. The first is, and you've already heard this earlier, but I did want to emphasize it, that the role of the secretary depends to a large extent on the arbitral tribunal that you're working with and what the arbitral tribunal would or would not like you to do. It also depends on what the parties consent and have agreed for the tribunal secretary to do, and also on the institutional framework. So for instance, we've already heard that the ICC has certain guidelines, the LCIA has certain guidelines. What do those guidelines say? So when you're thinking of the role of the tribunal secretary, you need to be aware of the framework in which you're operating. And that framework is largely composed of the 3 elements that I've just mentioned. That's the first point. The second point is that the role of the tribunal secretary may differ depending on whether or not you're in an institutional arbitration. And Lindsay and others have already talked about this earlier. When you're, for instance, working in a ICCID arbitration, you have the ICCID appointed tribunal secretary that performs a large number of the administrative and organizational aspects. And therefore, if you're appointed by the arbitral tribunal to assist them in that kind of an arbitration, then your role will be slightly different than it would be if you were acting in an ad hoc arbitration. So also keep in mind that your role may change when you're thinking about working as an tribunal secretary in certain forms of institutional arbitration. That's the second preliminary point. The third preliminary point, and I think this is quite important, it's that the role of the tribunal secretary sometimes evolves as the arbitration evolves. So yes, you will have a charter, so to speak, before you start exercising your mandate. But do keep in mind that an arbitration it has a life of its own. Parties make requests, suggestions, and the role that you're expected to perform might change from one year to the next, might change from one case to the next, might change within a case, depending on how the arbitration evolves. So keep in mind that while you do have an idea exactly of what is expected of you as a tribunal secretary, you do need to be a little bit flexible and cater to the needs of the situation as they arise as the case progresses. So those are the three preliminary points that I wanted to make, which really set out a broad outline of the specific tasks. Let's talk about them then. What are the specific tasks that you're expected to perform? So when I'm talking about these tasks, as the other speakers have done before me, I like to think of it as two separate kind of categories. The first is the organizational and the administrative category, and the other is the so-called more substantive or non-organizational or non-administrative category. So if you're in the first basket and you're thinking about what tasks you will be expected to perform or you can expect to perform, subject to, of course, as I mentioned earlier, the framework within which you're operating, what administrative or organizational tasks can you expect? So for instance, it's something that comes almost normally. It's drafting correspondence to the parties, sending it to the parties on behalf of the tribunal, organizing and maintaining submissions and exhibits. So in the course of an arbitration, once procedural order number 1 is in place, you will have certain rules established there for setting out, how the parties should make their submissions, within what formats they should apply, whether in this digital age, whether those submissions have to be automatically uploaded onto a file sharing platform, what the nomenclature should be. You'll be expected really to check all of those things, make sure that the submissions are filed on time, and make sure that they are complete. Translations, if any are requested, are fully meeting up to the rules that the tribunal have set. So basically organizing and maintaining all the submissions and the exhibits. You will also have the responsibility potentially of organizing hearings and meetings, not only between the tribunal members, but sometimes there are procedural issues that arise in the course of an arbitration, and the tribunal may, for instance, wish to have a hearing on interim measures, or may wish to have a larger number of procedural meetings with the parties. So coordinating, organizing those, or even in fact, in some instances, suggesting those could be something that falls within the remit of the tribunal secretary. Another aspect is making sure that the invoicing and the overall case proceeds are working, disbursements are made, raising invoices, etc. Now, when you're in an institutional framework, mostly the institution takes care of all of this, and the tribunal secretary doesn't. But I did want to mention this because when you're working in an ad hoc context, in some instances at least, where there is no separate fund holding entity appointed, the tribunal secretary may be responsible for soliciting periodic invoices from the arbitral tribunal and making sure that those invoices are paid from the case account, asking for advances from the parties, etc. So those are administrative and organizational tasks. There is also, in some instances, in some arbitrations, where the tribunal asks for simultaneous submissions. You, as a tribunal secretary, may be tasked with receiving both those submissions. And then once both submissions are separately received from the parties, from sending them out to the entire list of relevant people for the arbitration. So coordinating simultaneous submissions is something that you might be expected to perform as well. So those are just an idea of really the concrete administrative and organizational tasks that you might be asked to perform. Now we come to the so-called more substantive tasks. And again, like I said earlier, they vary. They depend on the framework within which you're operating. But you could, as tribunal secretary, for instance, be asked to review the parties' submissions when they come in. Sometimes parties make requests, but they don't clearly articulate them. And those requests need to be discussed amongst the members of the tribunal in an urgent fashion. So the tribunal may task you with reviewing submissions to make sure that it doesn't contain any urgent request. When you may also be asked to review the parties' press for relief to make sure that the press for relief haven't drastically changed from one submission to the other. This is, for instance, something which is particularly important in the ICC context, where the press for relief are supposed to be really linked to and limited to the prayers for relief as the tribunal sets out in the terms of reference. You also might be asked to keep account of the amount in dispute. Sometimes from one submission to the next, the amount in dispute increases considerably, and that has a knock-on effect on the tribunal fees, etc. And you may be asked to keep an eye on that as well. More contentious roles that you may be asked to perform are preparing drafts of procedural orders. And of course, when we say procedural orders, we mean orders of procedure. But sometimes procedural orders are far more substantive and they regulate some substantive rights as well. So when you're asked to prepare procedural orders, it could also mean more substantive orders in the sense of the effects of the effects that it has on the rights of the parties. Now, in those procedural orders, you could be asked to prepare a summary of the history of the procedural history of those orders, the chronology, prepare a chronology of the facts, a summary of the parties' positions, etc. So that's, I think, something which really occupies a lot of time, preparation of procedural orders. You might be asked to attend the meetings of the Arbitral Tribunal, take notes of those meetings. And also, again, which is, again, varies from case to case, but you might be asked to conduct legal research on specific issues that arise in a particular case. You might be asked to prepare summaries or questions to witnesses that the Arbitral Tribunal can then discuss and potentially raise to the witnesses in the course of a hearing or even thereafter. The tribunal may ask you to prepare a legal memoranda on certain specific issues or summarize the parties' submissions in respect of a particular legal issue. So the tasks are really varied, and they really go, and as has already been mentioned earlier, they really go to making the job, facilitating the decision-making function of the arbitral tribunal. And that's what really you should keep in mind. You do have an idea of the tasks at the beginning, generally at the beginning of the arbitration, when the letter setting out the tasks is sent out. But like I said, it is something which can also evolve in the course of an arbitration. I hope that gives you an idea. Before I concluded, I just wanted to talk about a few decisions by national courts which have recognized the tasks that an arbitral secretary can perform. And we've already heard a few of these decisions earlier, but I thought that it's useful to see, useful to mention, what tasks courts have really recognized that arbitral secretaries can perform. So you have, for instance, Sonatrach versus Statoil, where the English High Court said that it was fine if a tribunal secretary prepared documents for a tribunal's decision. So, in that particular case, the tribunal secretary was asked by the tribunal to prepare a formal legal memoranda on 3 issues. And the court said that this is fine. We don't see a problem with this. I understand that later this was now become a little bit contentious, but from the court's perspective, it is really not controversial. In another English High Court decision of P versus R, the court said that it's fine for an arbitral secretary to prepare drafts of orders. And while it said this, it did not really draw a distinction between substantive parts of orders and non-substantive parts of orders. It said that it's fine for a tribunal secretary to prepare drafts of orders, which I understand to mean the entire order, in draft form, of course, for the tribunal's review and approval. It said that also it was fine for a tribunal secretary to be asked to analyze the parties' submissions. And so far, it went on to say that even if it was fine for the arbitral tribunal to discuss its decisions with the tribunal secretary. Of course, the court emphasized that all of these functions have to be done under the supervision of the arbitral tribunal, and the decision-making function must be exercised by the arbitral tribunal. But anything short of decision-making, the secretary could be involved in. We then have the Swiss Supreme Court, that in applying the SCI rules, or now the Swiss Arbitration Center rules, found that it was okay even if an arbitral secretary was asked to exercise a judicial function, but the parties have to consent to it. So, it seems to go even further. The court seemed to recognize that arbitral secretaries can even exercise the decision-making function, but of course, subject to the parties' consent. And the last case really I'll mention is an ICCA case. where you have an AS versus Hungary. The Arbitral Tribunal delegated, again, a decision-making function to the tribunal secretary with the consent of the parties. And that was found to be fine as well. There was no real problem that was found with that. What the parties agreed there was that the tribunal secretary would review certain redactions that have been made by one of the parties to see if those redactions met with the applicable protocol that the tribunal had put into place for redacting confidential information. So what I wanted to convey here is that the tasks of an arbitral secretary really are varied. They can change subject to the framework that you're working in, and have an open mind. Keep in mind what Nusha said as well, that if you think that it's going too far, it is your sort of your responsibility to put a stop to it. But everything that facilitates a decision by the arbitral tribunal seems to have been accepted, at least by a variety of courts in a variety of different cases. So having said that, I turn to, I believe Ibe Fubara has joined us, but perhaps it's better, with your permission, Ibe Fubara, to pass the floor to Crystal first and then back to you.
That would be great if Fubara agrees to that. I think that would be okay.
No,
Fubara, do you mind?
No, I don't. Please, go ahead.
Great. Thank you. Yes, I think that this way we can actually avoid going back twice. And so basically what I will talk to you after thanking, of course, Young ICCA and the organizers of this workshop for this amazing opportunity to share with you our thoughts and experiences as tribunal secretaries, is, as Rahul mentioned before, I will be focusing on the hearing and on the award and everything that should happen in between, and all the tasks that you as tribunal secretaries may be asked to perform during that period of time. So focusing on the hearing and before the hearing, there usually is a lot of preparation towards the hearing. So one of the first things that needs to be done is drafting a procedural order in which everything related to the hearing is regulated. And so most of the time, preparing that first draft and sending it to the parties after it has been reviewed by the tribunal lies within the tribunal secretary. Let's keep in mind that now with virtual hearings, what normally happens is that attached to that PO, you would also normally have to have a protocol that actually provides for the different scenarios that can come up in a virtual hearing. So just be mindful of the, and I will talk briefly about the different scenarios if you have a virtual hearing or if you have an in-person hearing. But before COVID, we didn't really have as many virtual hearings. And so there was no protocol, but it comes in very handy for virtual hearings. So, and there are several institutions that have drafted their own. So make sure that you look at those before issuing the PO, and that actually the protocol becomes an annex to that PO. After sending to the parties, or while sending to the parties that draft PO, normally the tribunal will like to have a pre-hearing conference call in order to basically discuss that PO and make sure that everyone is on the same page and everyone agrees on how the hearing is going to be organized. So organizing that pre-hearing conference call will be part of the tribunal's tasks. Sometimes during that pre-hearing conference call, you would run the test if the hearing is going to be virtual. If not, you would have to plan to have another test run so that everyone gets connected and you make sure that in a virtual hearing, everyone can hear and speak and everything goes on smoothly. Things can still go wrong, but if you run a test, it will not be on you. Then moving on to other administrative tasks that you might be asked to perform before the hearing. That would be maybe preparing bundles for the tribunal or for the president. Also preparing maybe pen drives with the entire case file. Sometimes those are asked to the parties, but sometimes the tribunal secretary prepares them. I've also been charged with preparing, for example, bench memos for the tribunal before the hearing. And also, what I do for myself and to be ready for the hearing would be to prepare a small chronology with the date, the fact, and the document. Just because that will help me go through everything, make sure that I'm prepared. And also, it's very helpful during the deliberations because sometimes the arbitrators will remember the facts, will remember the things, but they won't remember the exact document. So it comes in handy to actually help them to have the documents also in hand with the facts. And of course, that's by no means something that you must do. It's just something that I normally do and that I think that I recommend that you do. And then there are more, I would say, organizational tasks that sometimes fall within a tribunal secretary's lap, which is, for example, booking a location for the hearing if the hearing is going to be in person, finding court reporters, finding translators, making sure that there is food for everyone, making sure that you know the allergies that everyone has, so that someone that eats kosher or that is can't eat gluten actually can eat during the hearing, and then booking flights and hotels, those kinds of things. In my experience, most of the tribunals that I have worked for did not have infrastructure in the place where the hearing was going to take place. And so most of the decisions were actually deferred to the parties for them to actually take. And so that I wasn't involved most of the times in all of these tasks, but I have seen other tribunal secretaries have to deal with this. So I put it out there just so you know. Another thing that I have had to do sometimes is to go to the hearing site the day before the hearing starts, for example, to make sure that everything is set up, that all the computers, that everything for the transcripts and the right setup of the hearing room is made, that the bundles are close enough to the arbitrators, and all those stuff actually happen. And then in the case of virtual hearings, what I've had to do is liaise with the virtual hearing provider in order to make sure that everything is under control, that they don't need anything, and that everything is ready for the following day or whenever the hearing is going to happen. And then turning to the hearing, there are differing points in what will be your main task during the hearing. I would say that it comes down probably to two. Number one, make sure that no one falls asleep. And I mean no one in the tribunal falls asleep. Fortunately nowadays it's not very frequent, but I must say that in one of my first hearings, the exit secretary, because in that case it was an exit case, there was a tribunal secretary from the institution, and then I was assistant to the tribunal, and the exit secretary made very sure that one of the arbitrators, who was an amazing person, but was I would say advanced in age at that time, did not fall asleep during the hearing. And that was very easy because he just, brought coffee, make sure that he passed notes frequently, so that, if someone is actually thinking in a way that it seems like they might be sleeping, that doesn't happen, So that's number one. Number two, I would say keep track of the time. And there are excellent apps nowadays to do that. I think that one of the recent ones that I've used is called Time Tracker or something like that. And actually it allows you to set different timers for claimant and for respondent. And it tracks how much time you initially had and how much you have consumed. And so it's very easy to, at the end of the day, report to the tribunal how parties have spent their time. There are, of course, many ways to do it. I've seen other tribunal secretaries use Excel spreadsheets with formulas on them. And so, you can do it however you want, but just since the tribunal is going to turn to you for that, just make sure that you find a good app to do it, or a good way to do it, and that you can deliver on that. I must also say that, like Lindsay said before, that they're really happy when there is an assistant to the tribunal. I, as tribunal secretary, was also very happy when I was working with ICCID, because it was easy to, double check with them on the times if that was necessary, and to actually work together to ensure that everything was, going on smoothly. I would also encourage you to maybe take notes during the hearing if you want, but just make sure that you don't get distracted with your computer during the hearing. I've even seen arbitrators get distracted with their computers or with their cell phones during the hearing. So, just make sure that you just use the computer for what you have to and not for something else, because, it's your job to listen, as is the arbitrator. So, and this is a very personal recommendation. I would recommend that you ask the tribunal, the president of the tribunal and the other members, whether they would like you to organize a dinner, and include also the ICCID secretary or whoever else is helping from the institution in the case, just to network, to make sure that you get to know the other members of the tribunal, and that you get to know them as well in a more personal role, since sometimes you're only working with the president and it's hard to get to know them. I think that is something good that you can do that will also enhance your network. So I leave it there for you. And then moving on to after the hearing, comes some of the best parts of the proceeding, right? And so attending deliberations is one of my favorite parts. Reading the different members of the tribunal during those deliberations and actually helping them if needed. I think that it's very useful to have the main documents printed out for the deliberations, for example. And as I said, if you have this chronology and you can actually point to different documents when they are needed or called on by the tribunal, that is very helpful. And then I suggest that you also, oftentimes not all the members of the tribunal are equally prepared. And so making sure that you provide those members that are not so prepared with some extra help or support in whatever they need. I think that wins some points, and that makes you a better tribunal secretary, because in the end, the fact that everyone is able to discuss in equal terms makes the discussion more enriching. So that is something that I would recommend. And then I have seen different types of documents go out after the deliberations. For example, I've seen procedural orders, so post-hearing procedural orders specifying to the parties the next steps, maybe instructions for post-hearing brief, or dates, different things. So that is one thing that you might have to prepare. Also, post-hearing questions to be sent to the parties so that they can actually answer them in the tribunal. So after the deliberations, or during the deliberations, the tribunal might come up with some questions that they want the parties to answer in their post-hearing briefs. So that can be included either in a post-hearing procedural order or in a simple letter sent by the tribunal to the parties explaining this and giving instructions for both the post-hearing briefs and the submissions on costs. Finally, turning to the award. Here I have several recommendations, which I will go through very fast, because I know that I'm running out of time. So first is start as soon as possible. It's never too early. In fact, when I act as arbitrator, I try to go to the hearing with the first draft, especially where I have the facts and the positions of the parties, which will of course then be adopted. But if you can get to the hearing with that already, it ensures that you actually have a very good command of the case. then what has worked for me in the past, and this might differ from one person to the other, but what I have seen work for me in the past is to have a debrief meeting with the president of the tribunal, very near the hearing, so after the deliberations. And in that meeting, what I would discuss is, number one, the structure of the award, the main decisions that the tribunal has or wants reflected in the award, what parts of the award I should draft and what parts the arbitrator wants to draft, timeline for deliveries of those parts, and then a checklist for the award, right? Which, of course, the ICC has their own, but if you, and there are other sources where you can find checklists for awards, the IBA Toolkit on Award Writing, and others. That will be the meeting that for me is the most important, because it is where I actually get to discuss with the presiding arbitrator what it is that he wants from the award, and what timeline we actually have, because otherwise it could be a quite daunting task to undergo. And then after that meeting, what I would do is that I will first make a skeleton for the presiding arbitrator to look at. And if he agrees, then start writing the parts of the award that are appropriate for me to write. And I will not go into what is appropriate and what is not. But I will say that I subscribe to some of the decisions that have been pointed out before, in the sense that the fact that you write even parts of the decision doesn't mean that the authority of the tribunal has been delegated on you, especially if, number one, that those parts of the decision are reviewed by the entire tribunal, and second, if they take responsibility for those parts. So when you start drafting, what I would do is start salamming the problem and cutting it, in little pieces so that the task doesn't seem so hard, and then just start drafting. And once there is a final draft, I normally make sure to introduce all the changes that have been sent by the co-arbitrators and the institution, which might also have comments. And then, and very, very important, this is extremely important, please write it down and make sure that it never happens. Do not ever issue an award if there's not enough money to pay the entire tribunal. This is crucial, So you actually need to make sure that there is enough money to pay everyone, even before you have a final draft and you're circulating it, or while you're circulating it, making sure that this happens, so that otherwise you can ask the parties for more money, and then collecting signature pages. And for this, what I would normally do is to liaise with the institution and make sure that we do it in the way that is the most appropriate for them. At the end of the whole process, you will have read the award many times, and you will be very familiar with it. But I would encourage you not to give up on it, because sometimes tiny little changes from an arbitrator can actually change the significance of parts of the award. So just read it one more time and make sure that everything is coherent, and that the work is complete, and that nothing has actually changed what has been discussed. And finally, when you print it, or if you're sending it through email to the institution for them then to communicate it to the parties, what I have seen done, which is very useful, is to actually clean the award for metadata, which is not a very difficult task to do. You just pass it through a folder, and it just erases, all the computer trail of the document, which is often very useful. So if you don't have to do that normally, I would encourage you to do so. And then get paid for what you have done, because you have probably done a great job, And it has been amazing to work with the tribunal, and they have been very grateful as well. So get paid for your job. And finally, since I'm going to have to leave before the end of this session, I would say that my number one tip for arbitral tribunals is to anticipate the tribunal's needs. And with that, I will pass the floor to Ibi Fubara for him to speak about the first part of the proceeding. Thank you.
Thank you so much, Crystal. Thank you, Raul, for covering up. I had internet glitches, so that's why I couldn't continue at that point. Well, I think we just have a few minutes to round up. So I was talking about the appointment of the Arbitral Secretary, and these are things that had already been discussed, so I may not really spend so much time on it. But to add that when the Arbitral Secretary, in the way I see it, when the Arbitral Secretary is suggested first by the Arbitral Tribunal, maybe the chairman or presiding arbitrator, I believe that the proposed Arbitral Secretary should initially have a discussion with the tribunal or the sole arbitrator that is intending to present in before the parties, at least to discuss remuneration. However, that is eventually to be left to the parties and to the tribunal. It's been discussed here that in dealing with remuneration, there are certain considerations. The first is if the fees of the tribunal is going to be ad valorem, in other words, it's going to be lump sum, or it's going to be based on hourly billing. So if it is lump sum, first of all, like I said, the arbitral secretary may have had an understanding of the kind of fees he may want. However, it is left for the parties and the tribunal to determine. So if it is lump sum, then it has to be in accordance with the fees that the parties are going to pay to the tribunal, in which case the fees of the arbitral secretary will come from the fees already paid to the arbitral tribunal. But if it is hourly, like had been discussed before, then the tribunal, the arbitral secretary will have to be paid in accordance with the fees earned by hours spent in doing the work. So I just wanted to rush to that because I know that we don't have enough time to deal with that. Then if he's appointed, he carried out his work. If he's not, then the tribunal will have to. If the party's objection succeed for the appointment, then the tribunal will have to maybe resuggest another arbitral secretary, give them or continue with the proceedings without an arbitral secretary. Now it depends. If the issue is as to costs, if the parties feel that they're going to incur so much to bring in an arbitral secretary in these proceedings, then the tribunal may continue with an arbitral secretary. If the issue is as to the qualification or the profile of the proposed arbitral secretary, or there's an issue of conflict of interest, if the arbitral secretary is eventually appointed, then the tribunal may decide to suggest or propose another arbitral secretary for the parties to consider. But at the end of the day, if an arbitral secretary is eventually appointed, then there is one thing, I'm just trying to rush here, there is one thing that the arbitral secretary must do. Once appointed, basically what the tribunal and the parties will first do in terms of hearing or meeting is usually the first procedural meeting. And the first procedural meeting is what sets the tone for an efficient and effective management of arbitral proceedings, which of course will include the responsibilities of the parties, and the arbitral secretary must be conversant with the orders that are contained in the procedural order that will be produced after the procedural meeting or the preliminary meeting, whichever it is called. Now, what are the things that there are certain things that the arbitral secretary may take note of and keep tab on? Shortly, first, the fees. the thing he will have to consider whether or not the fees of the arbitral tribunal have been paid, or there are certain costs that are outstanding. The arbitral secretary will remind the parties of those outstanding. Now, if there are time within which the parties are required to file certain processes or their pleadings, let's say the points of defense, and that the time is about to lapse, and the parties have not done what they're required to do in terms of filing, like I do as an arbitral secretary, I write to the parties, reminding them of the deadline, that within a specific period they are required to file their pleadings, or they are required to file certain processes for efficient and effective arbitral proceedings. Then, the form of delivering these documents is also very important. Before now, we've been dealing with hard copies. Even before COVID, we've been dealing with hard copies, and certain arbitral tribunals we are, however, having their proceedings virtually. But where the proceedings are to be held virtually, it is very important that the arbitral tribunal ensures that the platform, the online platform that will be used for the hearing, is functional, and that it is available for the parties to submit their documents. Also, for the ones for hearing, it should ensure that the platform for hearing is also functional for the proceedings. Now, what does it do? As an arbitral secretary, you're not required to wait until the date of hearing. I'm talking about virtual hearing now. You're not supposed to wait until the date of the hearing. You are required to ensure that at least a few days before the hearing date, that platform is functional, and that platform may not have glitches, while also ensuring that the platform is secured. Now, if it is physical hearing, that's in-person hearing, it is expected that before the date of the hearing, just as Crystal said, before the date of the hearing, as an arbitral secretary, you've visited the venue for the hearing, and you ensure that the place is set. And for you to know that it is set, you must also know the number of persons that are going to attend the hearing, because you're going to arrange some seats or get some seats arranged. The question is, how many persons are coming per party? If you do not know how many persons are coming or representing a party, you may not be able to have the requisite number of seats, for instance, per side. So before the hearing, know the number of parties that are coming or persons that are coming per side, and ensure that you visit the hearing venue and make sure it is set per side, and ensure that, of course, as Crystal has also said, ensure that if you're using recording facilities, either the recording facility of the institution that you want to have the hearing, or there is no recording facility there and you have to outsource it, ensure that those recording facilities are prepared and set and ready. Ensure that you have constant discussions and meetings with the persons that are going to conduct the recording, and ensure that they are ready for the proceedings. And then also ensure that before the date of the hearing, you have known the house rules and you have set them out. You can go to a location and you do not know where the gents are or where the escape routes are. Ensure that as is the arbitral secretary, you have taken note of all this. You can work with the administrator of the structure of the building that you're going to use, and ensure that you have everything set. And because on the date of the hearing, you have to notify the parties of the safety rules or the house rules. And there is also one important thing Crystal talked about, and that is refreshment. Before the date of the hearing, as an arbitral secretary, ensure that you have written to the parties and you have confirmed from the parties their preferences. You may have some vegetarians, you may have others who don't like certain things, or those that like certain types of food. Ensure that you've got their preferences. And
yeah, it looks as if we're having a slight connection issue with Ibn Fubara. So if you're comfortable with it, given the time, perhaps we might just move on to the last couple of items in our schedule. I'm mindful of time, and I know that our very special guest has been waiting very patiently for this period of time. So just to rejig the structure slightly, before we move to the sort of Q&A segment, we wanted to move on to our sort of guest speaker. Now, the majority of this webinar, as you would have seen, has been taken up with material from the Secretary's perspective. But we thought it would be remiss of us not also to provide you with a different perspective, that of the arbitrator, him or herself. And to provide that unique perspective, we're honoured and very grateful to be joined by someone who really needs no introduction, Professor Eduardo Zuleta. As many of you will no doubt know, Professor Zuleta is a partner at Zuleta Abogados in Bogota. He's a very experienced counsel and arbitrator. He's vice president of the International Court of Arbitration at the ICC, a member of the list of arbitrators of ICCID, appointed by the government of Colombia, as well as being a member of the governing body of ICCA itself. So with that short introduction, let me cede the virtual floor to you, Professor Zuleta.
Anna, thank you very much for your kind introduction. Thanks very much to Young ICCA for this invitation. And my congratulations to the panelists for this fantastic round of comments. I was supposed to give you some tips, but I got tips for me that are very relevant and important. So I thank you all very much. A few comments on what I've heard and on the Young ICCA guidelines on arbitral secretaries. Number one, there's no doubt whatsoever that guide has become the guide for two reasons. Number one, because as you mentioned, there are no uniform guides or rules in the different institutions as regards the appointment of secretaries. Most of the rules give the decision to the tribunal and the parties. So this guide has become the key guide for that. And number two, something that was mentioned partially, in connection with the appointment of secretaries, there is a cultural issue that has to be considered. There are jurisdictions in which the use of secretaries is basically unknown or infrequent. And at the other extreme, there are jurisdictions, particularly in domestic arbitration, but also in international arbitration, where the use of secretaries is mandatory. So the law provides for the use of secretaries. So you have to balance that cultural difference. Why is that? Because when you are going to appoint a secretary as chair of an arbitral tribunal, the first thing you have to do before even asking the parties whether they agree or not is asking your co-arbitrators. And you may find yourself in a situation where either both co-arbitrators or one of them is reluctant to appoint a secretary. So you, in that situation, you would have to decide whether you continue with the appointment or you will resign. So when you do not know your co-arbitrators, the first time you sit with one or both of them, my recommendation would be to ask for the co-arbitrators to their opinion on the appointment of the secretary as early as possible, if at all possible, before accepting the appointment. So if one of the arbitrators says no, and then you're not comfortable with that, then you can, at that point, step out without creating a major problem. Second thing, of course, is the consultation with the parties. You all have agreed, and the guides are very, very clear in that you have to consult the parties. Without the parties' approval or consent, you will not appoint a secretary. But now the issue again there is why, if one of the parties decides that it is not comfortable with the appointment of a secretary. And I've seen in practice two results from that. One, then the response from the president would be, of course, okay, that's fine with me, I will do the work. But then you will have to pay, if it's on an hourly basis, for the president to do work that could be performed by a secretary. The second approach that I've seen is the arbitrator simply resigns. And in a recent case that I can give you as an example, the appointment, a president was appointed. The president asked for permission to appoint a secretary. One of the parties said no. And then the other arbitrators, the two co-arbitrators, appointed a new chair, and the new chair, seeing the reaction from one of the parties, did not accept the appointment because that chair wanted again to appoint a secretary, and given that the reluctance of one of the parties, he preferred not to accept than accepting and continue without a secretary. The second point I would make is that, and you've commented on that, each case is different. Secretaries are not for all cases. Today, the arbitrations have become huge cases with counsel involved, firms involved, with 15, 20 lawyers on each side, thousands and thousands of pages. So you are seeing the appointment of secretaries more and more because of that. It is impossible for a tribunal to handle a file of that size, the size I'm mentioning, without the assistance of a secretary. It is not realistic to expect a tribunal to handle a file that on the side of the parties is being handled by 10 or 15 lawyers, and then the parties cannot expect a member of the tribunal just to handle the entire file by himself or herself. It is curious that we continue speaking or referring to purely administrative tasks. I think we need to be clear on that, and we need to be honest and open on that. Nobody would appoint most of the secretaries, not to say all of the secretaries, are brilliant young lawyers. And nobody would appoint a brilliant young lawyer just to make hotel reservations or to organize an USB or to classify documents. The duty of a secretary nowadays, and we have to be honest and realistic on that, the duty of a secretary nowadays is much more than an administrative rule. The courts, in the decisions that you have mentioned, have supported that. And the practice is supporting that. You see more and more procedural order number one, models of procedural order number one, including the tasks of the secretary that go far beyond merely an administrative task. The debate has been made, and we know that, around drafting sections of the award. But the same clarity has to be made regarding procedural orders. It is not the same to draft a procedural order stating, for example, I don't know, the safety measures for a hearing. That can be done by the secretary on his or her own, without any really involvement from the tribunal. It's not the same that a procedural order on a reference schedule, or a procedural order on bifurcation, or a procedural order on very delicate procedural issues. So there, the rule, of course, should be the same for procedural orders. The tribunal, what the chair or the tribunal cannot delegate is the decision-making. And there, of course, there's a very thin line of what is delegation of the decision-making. There's been a lot of debate as to whether, and you've mentioned that, whether a secretary can draft sections of the award. And the wording is, again, loose and ambiguous. Relevant sections of the award should not be drafted by a secretary. Appropriate sections of the award can be, what are appropriate sections? What are relevant sections? I think the trend is basically what the Brussels court have said, in the sense that to the extent that you do not delegate the decision-making, to the extent that the decision is the decision of the arbitrator, and it's clear that the arbitrator is guiding all the time the drafting of the decision, of the content of the decision, the drafting itself could be done by the secretary. But in any event, and you have also spoken about it, there has to be transparency with the parties all the time. From day one and from procedural order number 1, if you're going to use a secretary or you're going to appoint a secretary, you have to indicate to the parties what are the specific tasks, not in ambiguous terms, but in clear terms. I prefer not to use wording such as appropriate parts of the work. No, if the secretary is going to draft some sections of the work, you have to tell the parties that, making it absolutely clear that the decision-making remains on the tribunal. Now, before appointing a secretary, you have to ask yourself, why a secretary? And why is a term in terms of efficiency and in terms of costs? And you have to explain the parties why a secretary. And again, not in vague terms, but in clear terms. Because it would be efficient, and why it would be efficient. Because it would reduce costs, and why would the appointment reduce costs? And again, the specific tasks of the secretary in clear and unequivocal terms. I'm hearing more and more counsel saying, and that's very interesting for you as participants and drafters and of the guide. I'm hearing more and more from counsel that in appointing an arbitrator, counsel considers as one of the elements, particularly in complex cases, whether, and I'm going to use the term that I've been seeing used, whether the arbitrator has a team. And when they say a team, they are referring to somebody that can assist the arbitrator, somebody that can help the arbitrator manage the file, be updated with what's going on, and really give the arbitrator the possibility of evoking this immense task of huge files in construction cases, for example, in investment cases, making sure that the tribunal or the president has sufficient assistance for the decisions to be made in proper time, for the arbitration to be handled efficiently, and for an award to come out at a decent and reasonable time. So that's something that should be considered in due course. The other thing is that sometimes it is very difficult to know beforehand at the beginning of the arbitrator or the arbitration whether or not you would require a secretary. Sometimes you receive claims that seem like small claims, relatively straightforward claims. Then you see the file, you don't think there's a need to appoint a secretary, you proceed with your terms of reference, if it's an ICC case, with your procedural order number 1. And then when you receive the first submission, you realize that what seemed to be a relatively manageable case ends up being a huge case. And then you would have to react promptly. And if you at that time consider that you need a secretary, you would have to inform the parties as soon as possible. One of the things that the parties resist is the appointment of a secretary in the middle of the case, because then the parties would say, well, what's going on here? We are, I don't know, in the second round of submissions, we are going to the reference schedule, and now you want to appoint a secretary. Why is that? And it could create a lot of issues there. Another point that I would make is, and you have said that, but I think the key role of the secretary. And the tip for the secretary is a balance between having initiative and not being intrusive. That's a very difficult balance. Because a secretary with no initiative, simply waiting for instructions for everything, well, that's not helpful at all. So we need a secretary that has some initiative. And of course, a secretary that is intrusive, not helpful either. Crystal was mentioning, for example, the role of the secretary in the deliberations. The parties have to know that the secretary is present in the deliberations, and the tribunal has to be very careful as to whether and what sort of intervention would the secretary have in the deliberations. I've seen cases where the tribunal is debating a point, an issue, and then all of a sudden the secretary makes a comment or gives an opinion, and one of the arbitrators or the three arbitrators become angry, frustrated, and of course reject the intervention of the secretary because it's not the function. Now, of course, if the secretary finds out, for example, that the tribunal is referring to a wrong piece of evidence, in the sense that I'm referring to the testimony of Mr. X, and really what I have to have in mind is the testimony of Mr. Y, and I'm confusing, just to give an example, I think the secretary has to point that out. The secretary can help in finding key pieces of evidence that the president or the tribunal has identified, and it's normal to us to say that the secretary will, I know there's a document that was referred in the hearing, document X, Y, and Z. There's a section in the document that provides for X, Y, and Z. I need that document, I need that section. And it's for me to make the decision on what is the relevance of the document or not. But it's normal for a secretary to play that role. And last but not least, I think the role of a secretary is a very useful tool for the training of lawyers. There's been a myth around for quite a while in the sense that to be an arbitrator, you have to be counsel first. I do not agree with that. I know a number of arbitrators who've never been counsel, and we're seeing more and more very good arbitrators who have started their careers as secretaries to arbitral tribunals, because that's quite an experience. Number one, you would have the possibility of seeing the top law firms in the world interacting, advocating, debating. You will have the possibility of looking at different approaches as to how to do a filing, different cultures, different ways of seeing life. So I think this is a real path for young lawyers to get to the arbitration world and to the role of arbitrators. And I would like to conclude with something related to that. As my dear friend and the late Guillermo Aguilar Alvarez, who made the foreword of the guides, used to say, like judicial clerkships, secretarial appointments provide young lawyers to discern where advocacy meets persuasion. So I'm in favor, as you can see, of the appointment of secretaries. Is becoming more and more useful. And I would encourage the Young ICCA group to see if there's a chance to update. I won't say update the rules because the guides are they are what they are, but to update to some extent the comments because of these late court decisions and this trend to use more and more secretaries for tasks that, as I said, are not merely administrative. With that, I thank you again for your kind invitation, and Manas, back to you.
Thank you very much, Professor Zuleta, for those insights. They were very, very useful. In the next part of our program, and I think this will be the final. The final section, we had allotted some time for a Q&A, but what we might do first and we can get to a couple of those questions which have been coming in from everyone who's attended. What we might do first is something which we hope is slightly innovative, but it is a way perhaps of just distilling down to a short idea some of the comments and the observations that have been made during this workshop. And we're not springing this on our panelists. We did give them some advance warning that this would be coming, and Professor Zaletta, if you're here, if you're remaining on the call, feel free also to join in with this. But what we wanted from each of our panelists was their number one tip for being an effective arbitral secretary, stated as pithily and concisely as possible, which is not an easy task, I know, but we thought that would be a good way of ending the substantive session. So perhaps if I just go round my virtual screen here, and perhaps if I could start with Garth.
Sure thing. Thanks, Manas. So many potential tips to offer. I think mine would be maybe a slightly unusual one, and that would be check your ego at the door. Law is a competitive profession. Legal education is very competitive. If you've gotten far in the beginning of your career in the legal world, that's something to be proud of, and it necessarily involves a bit of self-promotion. There's certainly no shortage of ego in the legal world, but that's really something, and I think this goes for junior legal practice generally, but certainly for being an effective tribunal secretary, is set that aside. You're going to be, you are working in a support role. You're going to be working with brilliant arbitrators, hopefully with brilliant counsel. You need to be thinking about how to be effective for the tribunal, hitting on the balance of initiative and holding back that Eduardo was just talking about. And you don't need to be trying to show off how smart you are and how great you are and all of that. And, it's natural you think that. I think I'm pretty great. I'm sure most of us think I'm pretty great, but that really needs to be set aside. And really, I think the tribunal secretaries that I've seen run into problems are where it's a secretary trying to show off for the arbitrator, trying to show how much they know, and that's not helpful. If you do a good job supporting the tribunal, that will be recognized and it will be remembered, but you won't get there by showing off.
Very good. Sounds to me that that's good advice in general, not just for being an effective arbitral secretary. Why don't we move on to Lindsay?
Well, thank you, Garth. That was basically what I was going to say. My suggestion that I always give to people with maybe their first secretary appointment is get used to being the least important person in the room. And that is also good life advice, I think. But it's the same idea. I think I mentioned earlier, a lot of times you will know that case, you'll know that record better than anyone else, but there's just no reason to show that off. So I don't know. I feel terrible repeating the same thing. I guess maybe I could add, since that wasn't much of an addition, something else, which is, again, every task that you take on as tribunal secretary should meet the criteria of making the tribunal's life easier. That's sort of the goal. And so always keeping that in mind.
Very good. Panos?
Yes, very briefly, this tip comes actually from an actual experience, and it relates to the CV of the tribunal secretary. And as I said before, national courts are looking at the CVs of tribunal secretaries So there's no need to brag about the fact that you're drafting awards. You don't need to explicitly say it. You can say that you're assisting tribunal members or arbitrators in the conduct of arbitral proceedings and leave it there. Tone it down a little bit and don't be explicit about what exactly you're doing.
Good advice. Rekha?
Thank you, Vanessa. Yeah, well, my thunder has also been stolen both by Garth and Lindsay, but I totally agree. I wanted to call it differently, like something like being humble or something like that, but putting your ego aside is a completely good advice. And what I think helps often when you feel maybe a little bit frustrating, not being able to voice your opinion, etc., is to think about how much actual experience you're gaining. And as Professor Zuleta said, nowadays it's being recognized, the work an arbitral secretary does, so which will be very useful for you, whether you want to become an arbitrator or a counsel later or work for an institution. So I think that this is really an excellent general advice. And I am lucky enough in the sense that Francisca could not be with us because she had to actually assist to tribunal deliberations, but she gave me a list of her tips, so which are very practical in nature. But I would just tell you maybe, or try to sort of sum it up. In general, her message was to be very well organized and very much detail-oriented, as boring as that might sound. Basically, you're something like a project manager, and don't forget to really have all your lists, to respect all the deadlines, not just when a written submission is coming in, but any comments parties might make here and there, and do be very organized until the last detail. For instance, when you are sending something out to the parties, be sure that you actually check each and every email address, that no one is missed, and you don't send it to the wrong person. There's a very small things, but you have to be very detail-oriented and very well organized as an arbitral secretary. So that was Francisca's advice, just to be clear. Thank you.
Thank you very much. Nuisha?
Thank you very much. I will try to stick to the 1 minute. So indeed, put yourself into the shoes of the members of the tribunal, but of all members of the tribunal, while also knowing your boundaries. I think this is just another way how Professor Zuleta has put it, and some others before me as well. Then learn at the same time from every single member on the tribunal as well. It's an immense opportunity to look behind the scene, to see how others work, not only the person that you work mostly with, if you are a secretary who is affiliated to a law firm. And then don't be surprised about the myth that some of the great names in arbitration have created around themselves. They are assisted by tribunal secretaries who are brilliant as well. And so this is something that is the other side of the coin of, yes, be humble, but also note that everyone is actually working with this. In German, we say, alle kochen mit heißem Wasser, meaning that everyone is actually cooking with boiling water. No one is putting some magic into the pot. Thank you so much.
Very good, thank you. If we could then move on to Eugene.
Yep. So I will be as pithy as possible. My top tip is basically to know what you're supposed to do and do it well, and to not know what you're not supposed to do and not do it at all.
Very good, right on brief, Eugene. Thank you. I don't know, Ifubara, if you've got you are here. Okay, very good.
Thank you. At least I'm back. My takeaway here is that as an arbitral secretary, you should know the arbitration rules that's governing that particular arbitration, because sometimes you may be required to even guide the tribunal members. And the fact that you had, of course, not in the open, and the fact that you had acted as an arbitral secretary in another reference does not mean that the same rules would apply, because there are different rules. So be conversant, mine is be conversant with the specific rule that is guiding the arbitration and flow with it. Thank you.
Thank you very much. Professor Zuleta, I'm not sure whether we gave you advance warning about this, but we'd be very interested in your thoughts.
Briefly, 2 tips. Number 1, understand and accept cultural differences. It's very frustrating when a secretary starts saying, well, this is the way we do things in country X. This is the way we do things with arbitrator Y. So you have to understand and accept cultural differences. And the second, to me, most important, have fun. Do not be a secretary that is complaining all the time about the size of the file, but have fun. This is a once in a lifetime opportunity. Enjoy it.
Thank you very much. Given where we are with timing, I thought I would just pick up on one question that was raised during everyone's observations, which just struck me as interesting, and I'd be, any of the panelists should feel free to give their views on this. But one question that was asked actually anonymously was to do with the advent of automation in the years to come, and whether there are any tasks that are currently performed by arbitral secretaries on those cases where secretaries are required or deemed necessary, that could be automated or eliminated in the future. And I'm not sure if anyone on the panel has given that question much thought, but we'd be interested to hear if you had any immediate reactions to that.
Can I kick off? Thank you. I saw that question. I thought it was very interesting since, of course, the whole matter of automated decision-making is and talks already, and how artificial intelligence can help. So I thought that, and only as a background, in arbitration, especially commercial arbitration, it's nowhere, and it will be very difficult to get anywhere soon. But in investment arbitration, where decisions are published, maybe it could be. Now, a tribunal secretary is not supposed to take any decisions, as we learned today and repeated so many times. But I think there are a number of tasks indeed that could be taken over by some software, and that is maybe some tasks that Crystal was referring to as well. So the chronologies, for example, the preparation, the timeline, then getting out the dramatis personae, all these matters that assist for then drafting the award. I think that for sure I can see how it can be used, and I know that law firms already use that in counsel cases as well. So there I would say yes, to some extent, for sure, but or the research maybe even as well on certain topics. So that I can see that if the software is accessible and affordable, that indeed some of those tasks could be taken over by automated technology.
Very, very good. I don't know if any others have comments on that question. Lindsay, I can see that you've unmuted yourself, so maybe you do.
Yeah, I just once I had to participate in a debate where I was given the side to argue that AI was going to take over all dispute resolution, and I was horrified by having been given that as the side to debate. And then I convinced myself. So I do think that we will all be replaced by computers.
Yeah, a sobering thought to finish on. Well, I think that brings us to the end of our formal program. So on behalf of ICCA, Young ICCA, and all of our attendees today, I'd like to express my own deepest gratitude to our panelists for sharing their time and expertise with us today. We know your time is valuable and you've given us a lot of it, so we are extremely grateful. Look, we hope that you all enjoyed watching this part of the workshop. As Matt mentioned at the beginning of this call, one of the things that we do like to do is have a practical element to this for our attendees. And so the second part of the workshop, for those who have the time and the inclination, is a practical exercise. So if you'd like to participate in that, here are a few details. In a few moments, we're going to be pasting into the chat box of this workshop a link to a different Zoom meeting. Anyone who wants to participate in the exercise will simply have to click that link, fill out a few simple questions, and they will then receive a link to the new meeting. And I see that Anna's already pasted the assignment meeting link into the chat function. So thank you for that. It looks as if, given the number of attendees that we have here, there'll be no issues with the amount of people who want to register. So we do it normally on a first come, first served basis, but given the amount of people that are still on the call, anyone who wants to join will be able to. Once you enter the meeting, we'll send you the file to complete the practical exercise, and we'll explain briefly the process, and then we intend just to split you into groups, so you can exchange contact information, network with other members, and also decide on a plan of action to complete the exercise. As you will see, for those who can participate in this part of the workshop, the exercise comprises 5 questions that are designed effectively to replicate the type of practical activities you might be called on to carry out as an arbitral secretary. The deadline for the submission of the answers to those questions is going to be the 13th of October. So it's a couple of weeks away. So hopefully that will give you sufficient time to put together some interesting material. As long as your group submission is complete and of a reasonable quality, what we'll do is we'll also issue you with a certificate of completion, so that you have something concrete to take away with you from this workshop. And in addition, and this is something that actually our members do spend quite a lot of time on, we'll be reviewing and providing feedback on each submission to help you improve and provide you with suggestions for your future practice. And finally, as Matt mentioned, as a sort of incentive, we'll also be awarding the best quality submission or submissions with a prize, which is still to be determined. But based on past experience, those are usually pretty good incentives, and have in the past involved also the opportunity to connect with people who have spoken on the panel in question. So given that we now have the link, we'll start that meeting shortly. So you may see a sort of waiting for the meeting to start message until then, but just please hang tight until we're all there. And just a quick note that your camera and your microphone, they may be activated in the new meeting. So just a pre-warning that you may be visible to other participants in the call if that might be a problem for where you are currently. Okay, I think that's everything. Anna, I don't know if you wanted to say anything else before we leave.
I'm going to repaste the link just in case it got lost in the messages, but I hope to see all of you on the other side. Thank you so much for everyone that was with us today.
Very good. Thank you all.